428F sub 1088, 1977. And in that case, the court considered rehabilitation, which is now prohibited by the new policy statement, as being a sole ground, correct?
That's correct. In the case that Your Honor referred to
But nevertheless, back then, Bob relied on rehabilitation, correct?
Rehabilitation, absolutely, yeah.
And the Diatho case, I think you're minimizing it, that also was a New Jersey case where Bob made a motion to the court from compassionate release, and one of the factors was a change of sentencing, correct?
Absolutely, Your Honor.
So the two published opinions were both BOP and weren't limited to just personal circumstances.
That's certainly correct. Absolutely.
Counsel, you say the situations in which these would arise will be rare and unusual. Why in the world would that be the case? You've got somebody sitting in jail and they got 20 more years to look at, and you go in and say, gosh, I think there's like a 1% chance, you might be able to get out. The prisoner is going to say, well, okay, it's only 1%, let's forget about it. Every lawyer would bring these claims, and some judges are going to grant them and some are not going to grant them. And I'm not sure this factor is not something that Congress took into account. And it does seem that this is, well, why would this remain rare?
Certainly, Your Honor. And the reason it would be rare is precisely because of the habeas statute, that the defendant did have an opportunity, potentially, to raise these issues on habeas. Maybe he procedurally defaulted. He will then have to show why he procedurally defaulted. What were the circumstances surrounding that? Because merely procedurally defaulting on a potentially meritorious claim normally would not be found to be
okay.
compelling.
I think I have everything working.
Did the meaning of extraordinary and compelling reasons change in 2018 when Congress enacted the First Step Act?
That's not our position. Our position is that it has meant the same thing, and that would be the dictionary definitions of extraordinary and compelling, since 1984.
Well, until 2018, only the director of the Bureau of Prisons could invoke the statute, right?
That's correct, Your Honor.
Is it plausible that Congress intended for the director of the Bureau of Prisons to make motions for sentencing reduction based on an assessment of the strength of the evidence or any factor that has to do with the trial proceedings or the sentence that was imposed?
I do believe so, that it was at least possible, Your Honor, as referring back to the cases that Justice Sotomayor discussed.
Yeah, they're two isolated cases, but doesn't that seem to be far outside of the area of the director of the Bureau of Prisons' expertise?
Well, there could be
and
issues.
Responsibility.
That's certainly true, Your Honor, but I would suggest that the other agency that is involved in 3582 is the Sentencing Commission, and there was a delegation to the Sentencing Commission, whose expertise, of course, goes far beyond the Bureau of Prisons to set up guidelines. The Congress did not delegate that task to the BOP.
And why would our consideration be limited necessarily to what was in the purview of the BOP? I understand that there was an amendment that
Okay, guys,
allowed
does everything
the
look good,
statute
sound
or allowed
good?
these motions to be brought by a defendant and essentially bypass the BOP. So I'm wondering if that doesn't indicate Congress's intent to allow for the consideration of factors that the BOP either wasn't able
And
to
please
or
tap
wasn't
and like and do all that
considering.
stuff. I appreciate
Well,
it.
certainly, Justice Jackson, we do agree that when Congress amended the statute, the reason it did so, and it was quite explicit about this, was to allow more circumstances to be raised. It's our position, it's not because the BOP was not able by law to do so, but that the BOP was not bringing enough of these sorts of motions.
Well, counsel, you can't have it both ways. Either extraordinary and compelling reasons remained the same after the enactment of the First Step Act, which is what I understood you to tell me, or it changed in 2018, which is what you seem to have suggested in response to Justice Jackson. So which is it?
No, I'm not saying that the meaning of the words changed. I'm saying that what Congress intended in the First Step Act was to allow these sorts of motions to be made more broadly.
And in any event, I thought your argument was that Congress never gave content to extraordinary and compelling circumstances in the first instance.
That's
that
absolutely.
It, in fact, ceded that authority to the Sentencing Commission.
Absolutely, and Congress used words that were intentionally
So
broad.
this is a big question.
To allow
Does the Sentencing Commission get to decide what extraordinary
give guidance
and
on
compelling
circumstances
means?
that it might not have anticipated when it passed the
But
First
the
Step Act.
Sentencing Commission has not authorized this kind of activity, has it?
At this point, certainly for our case, the Sentencing Commission hadn't spoken. The current policy that was passed
Has spoken or
has not, for purposes of our case.
Right, and in your
They
opening,
did
you
did
therefore
actually
said the
file
question
an
whether they've
amicus brief in the
implicitly
second
prohibited.
case.
Isn't the question rather whether they've authorized this kind of motion?
Yes, in our view, by using words that are as open-ended as extraordinary and compelling, and then by explicitly delegating to the Sentencing Commission the authority to give guidance, that is the authorization. Congress did two things here. One, it used very broad language, and second, it gave an explicit delegation to the Sentencing Commission.
Right,
Counsel,
but the commission, I'm sorry.
No.
But the commission hasn't in turn said that this kind of legal error is a basis for this kind of motion, correct?
At this point, the Commission has not spoken to that. The Commission in
And
2020
shouldn't that be, or how relevant should that be in how we think about this? In
Well-
other words, the commission could, it's subject to legal challenge, but it could identify this kind of circumstance as the basis for such a motion, but it has not done so, even though it has been authorized, as you say, by Congress to elaborate on what the authorization means.
Yes, Your Honor. From 2018 until 2023, the Commission had provided no guidance that applied to defendant-initiated motions. So at that point, courts were simply acting under the meaning of the statute.
For a
So,
while,
yes, we
the
certainly
only way to get one of
expect-
these motions
we would
up
hope
was
that the
for the
Commission could
prison to bring it
provide
on your
further
behalf.
guidance on this issue, but
They had to
it has
say,
not
"Oh,
yet
this
taken
guy's
that opportunity.
80.
Counsel,
Can we
I
get
ask
him
you a
out of here?"
Question about whether you have to go to 2255 first or whether you can go straight to the compassionate release statute. You answered when the chief was asking you questions. In that interchange, you suggested that the prisoner would have to go to 2255 first because otherwise it wouldn't be a compelling circumstance for release. So are you reading kind of an
2255 is
exhaustion
another
requirement
statute
into
that can
compelling
change the
so that
sentence.
someone in your client's position would have to try to get relief through 2255 first before invoking this other procedure, or no?
No, Your Honor, that's not our position. Our position is that as part of the extraordinary and compelling analysis, courts would consider whether a defendant sat on his rights or whether he's taken all opportunities to enforce his rights. Even if a defendant did not go through 2255, he would still have the option to argue under 3582 that his situation is extraordinary and compelling, but his position would be weakened by the fact that he did not take the opportunity to enforce his rights.
Why would you ever bother with 2255?
Thank you.
Seems like it would be a lot easier to just go the other route, as long as you have some other circumstances to invoke.
Well, for the first reason would be that 3582 sets a very high bar for defendants. It has to be extraordinary and compelling. Also, the relief that a defendant can obtain under 3582 is limited. He can only reduce the sentence, whereas the relief under 2255 is much broader. He can attack his conviction. Also, there will be plenty of errors where a court will not feel comfortable simply releasing somebody, but rather would want to correct the error by remanding to the by having a new trial.
But a First Step Act error, I mean, you've made the position, and it's true, Congress changed it because those sentences were extreme, right? They were extremely long. And it seems to me that if indeed that's extraordinary and compelling, the disparity between similarly situated defendants who get the benefit of the act and who don't, I mean, why wouldn't that be extraordinary and compelling on its own terms? And plus, you know, there are downsides, too, to attacking the validity of your conviction, because then you could be subject to retrial.
That's right, Your Honor.
This is Benjamin Grunstein, counsel for the state of New York, or for the city of New York.
The phrase narrowly. There have only been, by our count, 12 cases since
Morning,
2018, when the First Step was enacted, where a court based on an argument that could have been raised on 2255, in part granted a sentence reduction. So courts have been using this very infrequently to grant relief.
But 2255 has some harsh limitations. You know, there's a short statute of limitations. There is preclusion of second and successive petitions for the most part. You know, can't you imagine that defendants who face those limitations, and you know they filed their 2255 motion 3 days late or something like that, that this would then be used essentially as an end run around those prohibitions?
Your Honor, I don't think it would be an end run precisely because a 3582, even if you do claim an error, will not necessarily be granted. It will be difficult for that. And I agree with Your Honor that there are harsh limitations associated with 2255. And Congress has stated those limitations are appropriate, but it doesn't mean that
I couldn't get access to the thing where I changed the name, so I apologize.
That those limitations are fair. And under certain circumstances, if a defendant misses a limitation by 3 days, he may not be able to challenge his conviction,
working on it every
but he should
day.
at least be able to argue this unfairness, the error and the unfairness of him not having been able to bring it under 2255.
I suppose what I'm suggesting is that, you know, Congress, for better or for worse, made a determination that those are the limitations that it wanted. And even to the extent that a judge thinks that they're unfair in all cases, in most cases, that I doubt that Congress meant for individual judges to override its own judgment.
Absolutely, Your Honor, and that's certainly a limitation that should be placed on 3582, that a judge cannot simply second-guess a decision made by Congress. But even where Congress creates a generally applicable law, such as a mandatory minimum, it doesn't mean that Congress even believed that in every case that would be fair to the defendant. And all we're asking for is that a judge can consider that the way the law has been applied to this defendant has been
Thanks for tapping everybody,
or even
liking and
erroneous.
hurting and all that
in
stuff.
response as well to Justice Kagan's point is the thought that the limitations that exist in the habeas context are relative to the actual aim of habeas and goal of habeas, which is vacatur of the sentence. It's also not discretionary. Where the defendant has satisfied the criteria
Under habeas corpus, if you win that, you lose. The sentence is just gone.
The court has
versus
to,
this other thing we're
according to
talking about, which is
statute,
up
give
to
him
the
habeas.
judge.
And so, yes, there are strict limitations, but there's also this particular goal. It seems to me that compassionate release is a totally different thing. And so, to the extent that compassionate release is about the court's consideration of a sentence reduction, one might think that the same limitations aren't intended to apply, that it's not actually an end run in any meaningful sense. These are just two different regimes, and it doesn't seem to necessarily follow that the considerations in one are mutually exclusive, such that they can't arise in the other.
That's absolutely correct, Justice Jackson, and it's worth remembering that Section 3582 is as much an act of Congress as Section 2255 and should be given respect.
Is there anything in the statute or the legislative history to suggest that Congress wanted the 3582 sentence reduction dynamic to be limited in some way by what could have been raised in habeas or what is happening in the habeas scheme? Is there anything that links those two in the text or even in the legislative history?
Absolutely not, Your Honor. And in fact, the court has given guidance about how when there's a potential tension between two statutes, how that tension should be resolved, and that's the Prizer line of cases. And it's not simply that one statute can be seen in some circumstances to evade the other. What happened in Prizer in that line of cases was that 1983 was seen as a potential end run around every single constitutional 2255 motion. And that's why the court found that a literal reading of 1983 would swamp the habeas statute. It would wholly frustrate Congress's goals. Here, allowing defendants to bring motions under 3582 C1A in the rare circumstances that they could get relief, having a sentence reduction under those circumstances would certainly not frustrate the procedural limitations under habeas. And for reasons I said earlier, courts should actually take into account those procedural limitations.
And in fact, it would enable the kind of quote-unquote safety valve that Congress expressly in its reports, et cetera, in describing compassionate release. That's, I think, the design of it.
That's absolutely correct, Your Honor, and that's precisely how the two statutes sit one next to the other and not in conflict. Habeas applies generally to claims of error relating to a conviction or sentence. 3582 is the safety valve that can be applied to reduce a sentence should all of the other avenues of relief fail.
But the question is safety valve for what? I mean, not every safety valve is a safety valve for everything. And I would not have thought that it's a safety valve in order to relitigate trial errors in the way that a 2255 motion is. That's the entire point of a 2255 motion. So, you know, I guess I don't see any evidence that Congress meant for this to be a kind of do-over statute.
Well, Your Honor, perhaps the best evidence of it is the words that Congress used. They said extraordinary and compelling. Those are words that don't have a specific meaning, and it's given to the court to decide what is an extraordinary and compelling circumstance. So there are cases, we cited the Trenkler case, where someone had been sitting in jail for years. He was sentenced to a life sentence, even though the statute under which he was convicted, which had been amended just slightly after his verdict, and that's why no one picked up on it, said that he could not be not be sentenced to life. So in that situation, yes, if he could have raised it under 2255, he should have, and maybe that detracts slightly from a finding of extraordinary and compelling. But when he's sitting in jail serving a life sentence that is unlawful, that's all we're saying is that that's something that courts should be able to consider as one of the factors, just as much as age and illness.
Well, suppose that a defendant, a prisoner, claims that there was a fatal error at trial, but doesn't bring a 22 after the direct appeal does not bring a 2255 for 3 years, therefore misses the statute of limitations. What would be extraordinary about that situation, and would allow the prisoner then to try to get this, to get a lot of the relief that could have been obtained, maybe all of the relief that could have been obtained under 2255 by filing a 3582 motion?
Well, Your Honor, certainly there can be some things that are extraordinary and compelling about those circumstances. One, we would have to understand what is the prejudice that that fatal error had on the verdict. Did it change it from an acquittal to a guilty verdict? Then, why did the defendant, if this was such a glaring error, why did the defendant not bring a 2255? Maybe he had a mental breakdown and couldn't speak to his lawyers during that time. We don't know the circumstances. All we're saying is that all of the circumstances should be considered as part of the extraordinary and compelling analysis, the same way that personal circumstances.
I understand that.
So I made a mistake a second ago. This is the counsel for the defendant, for the prisoner.
Suppose you're advising a whole string of prisoners who have been convicted, they've lost on direct appeal, and for one reason or another, they all have claims of trial error or some other flaw in their conviction, but they're all barred from proceeding under 2255 because of the statute of limitations or some other factor. And you look at their claims, and you
it's going to be
think
different in
this
every
is
state.
not a ridiculous claim. Would there be any circumstances in which you would not file a motion for sentence reduction?
Well, Your Honor, I think the same could be asked of anyone who has any medical illness or is approaching older age. Is there any reason they wouldn't? And this is precisely what the Sentencing Commission is authorized to do, is to put in guardrails. But to Your Honor's question, I think the close calls of when there's potential error, I'm not sure that that's the sort of unfairness that courts would typically find extraordinary and compelling.
Well, I'm not even talking exclusively about close calls. I'm talking about arguments that are not so frivolous as to damage your professional reputation if you brought them.
Well,
Wouldn't you always do that?
Absolutely, Your Honor. And
So if this
similarly,
isn't going to be unusual,
I think what
it's going to be standard.
I think what would be unusual is that courts would find the compelling circumstances that we're talking about. The First Circuit I cited in our reply brief, after Trenkler in 2022, there's not been a single case that we found where a court has granted a compassionate release motion in a situation where an argument that could have been raised on habeas was the basis for that motion. So we haven't seen that level of motions being filed, but we certainly anticipate, and Congress anticipated, that the Sentencing Commission can put the guardrails the same way that the Sentencing Commission, I'm sorry.
Keep going, sorry.
I'm just going to say the same way the Sentencing Commission dealt with the flood of these compassionate release motions during COVID.
But the Sentencing Commission, like Congress, has not authorized or envisioned or articulated anything close to this kind of legal error being the basis for this kind of relief. And that concerns me because, as Justice Kagan said, you don't see anything suggesting that Congress wanted a do-over kind of statute, but you don't see anything from the Commission either. Your case would be obviously quite a bit stronger if you had the Commission having identified this as they have with some other things.
Certainly, Your Honor, but I think that what we should
It's a
read
tough one,
into the
Robert.
Commission's silence on
Depends
this
on a couple
is
of
that
things.
these will be
Thank you,
cases
Aaron.
that will be few and far between where a court would actually find the circumstances.
Well, how do we know that? I mean, first of all, as Justice Alito says, I think they'll be far more common that they're brought, so that'll be a whole new docket, one imagines, of these kinds of motions. But how do we know that individual district judges are going to, as your word, be modest or routinely deny these?
Well, Your Honor, certainly we haven't seen in the circuits that have allowed it, we haven't
But
seen.
if you win this case, one imagines that could, supercharge the efforts
Not
to
necessarily.
use this.
That's
In
correct.
fact, you would want that, wouldn't you? Don't you want this to be used more often?
Well, I'm just representing my current
If it's
client.
correct.
But
The idea is
Your
this
legal
guy,
position would-
the
Our legal
judge here
position
looked
is
at
that
the
it should
case and
be-
was like,
this should
I
be
don't think this
something
guy
that
should have been
be
convicted.
in the mix. And
It
certainly
looks to me
courts
like
will take into account several
his
things
co-defendants
that I think would limit their exercise
lied
of discretion.
to
First, they would
shift
take
the blame
into
to him.
The fact that there's the law of the case. If an issue had been raised, courts should not be revisiting it. Second, I think it's likely that these sorts of arguments will be made mostly in cases of mandatory minimum sentences, where the element of unfairness that arises from the error could not have been considered before. So we're seeing how the universe of cases where this sort of argument would be made is getting smaller and smaller. And rehabilitation is certainly an area where you would expect many motions to be brought in. There have been, but still the number of total compassionate release motions is modest, and if the Commission speaks more, will be even more modest.
Thank you, Counsel. Justice Thomas? Justice Alito?
Well, you just mentioned mandatory minimum sentences. There are a lot of district judges and other federal judges who don't like mandatory minimums. So if a prisoner has been sentenced to a mandatory minimum sentence, could a district judge say, if a motion under 3582 is made, you know what, that mandatory minimum is too much under the circumstances of this case, so I'm going to grant a sentence reduction?
Well, Your Honor, Section 3582 does allow sentencing under 3582, under the mandatory minimum for any extraordinary and compelling reason. But certainly it's our position that a court could not just say, I don't like mandatory minimums, and therefore I won't apply them. It has to be something about the unfairness of that mandatory minimum in a particular case.
Would you agree that one of the principal goals, or a major goal of the Sentencing Reform Act, was finality? The Sentencing Reform Act got rid of parole. It didn't like the situation where someone would be sentenced to 30 years in prison. This was standard at the time. Maximum, a life sentence was considered to be 30 years, but then after 10 years, the person would be paroled. It got rid of all that.
Sorry, Teresa.
Would you agree that that was a major goal of a major objective of the Sentencing Reform Act?
Absolutely, Your Honor, but it was also a goal in 3582 to have a safety valve where judges could still exercise discretion at a later point in the process.
Thank you.
Justice Sotomayor?
Thank you,
Counsel,
guys.
I'm assuming here that a basic part of your argument is that actual innocence claims are not cognizable under 2255 at all.
That's based on our understanding of what the court has said to date.
We've never said they are.
That's correct, Your Honor.
And so whether 2255 would be implicated in some other claim is irrelevant to your claim. This is an issue that couldn't even be raised
Thanks,
there,
guys.
not
Oh,
because of
thank
a procedural bar or anything else, but it's just not cognizable.
That's correct, Your Honor, and that's one of the difficulties in this case, is that
All
if
right,
the
now,
court's... yeah.
may I go back to a problem I have with your case, which is all of the facts that Judge Hellerstein relied upon were known to him at trial. He
Ooh,
knew
it's the
what
same
your client's
judge.
claim of innocence was. He knew all the evidentiary weaknesses that he wrote about in
So
his current opinion.
12 years later, he came
knew
back
that
and was like,
only one shot came from your client's gun, et cetera, et cetera. The only thing he did not know was the exact reduced sentence that the co-conspirators would receive because they were sentenced after your client. But he knew they were going to get a substantial reduction because they were cooperators. How do we call that new and compelling evidence?
Extraordinary and compelling.
Compelling or extraordinary evidence.
This is the question, guys.
It's all
Extraordinary and
nothing new.
compelling. What is
I would have
extraordinary
an easier
about this
time
story?
if I thought
What is
that
different than normal
actual
about this story?
innocence had been proven after the fact.
Nothing's
Yes,
changed.
Your Honor, there was another fact that Judge Hellerstein
okay.
did take into account that he had not focused on previously, which is that the getaway driver was sentenced to 2 years in prison. And that suggested to him that the government itself had concerns about the credibility and the reliability of the cooperator's testimony.
All right. Now, you said earlier, and I agree with you, both age and medical condition or
Thank you,
any
Seth.
other reason doesn't ever stand alone, because there are old people who are not released from prison. There are sick people who are not released from prison. It's one among many circumstances. Your claim of, and I put it in quotes, actual innocence, doesn't stand alone. But what does it stand with in this case? There certainly was no medical need. There's no age need. There's no extraordinary circumstance to this individual. So why isn't it only one factor?
What it stands with, Your Honor, is the fact that despite the judge's concern about innocence, that this defendant was sentenced to a life in
That is what bothers me.
Okay, yeah.
But Your Honor,
This shouldn't be about
that it's
him
judge's
deciding later that
disquiet
maybe I made a mistake.
As opposed to an individual circumstance.
This should be about
Because
something
no
that
matter how you
changed.
look at extraordinary and compelling, it focuses on the individual, not on the judge's disquiet. By the way, I was a district court judge, and I have a great deal of respect for the disquiet that sometimes judges feel.
But
It happens to every district court judge. There's a case where you really struggle. But can we, in the facts of this case, to note that that is an extraordinary circumstance?
Well, what I would say, Your Honor, is that this is the sort of discretion that judges generally have in sentencing, and it's reviewed on appeal for abuse of discretion. The Court of Appeals didn't review it for abuse of discretion.
Well, I agree with you, and maybe that's what they should have done. But I am troubled by this. Thank you.
Justice Kagan?
I mean, just to continue in that vein, do you think that the district court here, on the initial trial, could have received the jury's verdict of guilt and said, you know, I'm not going to overturn that verdict of guilt. I have no basis for doing that. But in the sentencing, I'm going to reduce the sentence because I feel disquiet with respect to that verdict. Could the district court have done that?
Well, certainly not in this case, Your Honor, because it was a mandatory life sentence. But as a general matter, while the court does have to take the verdict as given when conducting the the guidelines analysis and the 3553 analysis, how the court weighs the different factors, such as personal circumstances, the nature and the characteristics and history of the defendant. It can certainly weigh those factors.
Well, personal you brought into doubt. I really was limiting it to would it be appropriate for a district court to say, I'm not overturning the jury verdict, but I'm not sure I agree with it. Therefore, I'm going to reduce the sentence below what I would ordinarily give.
I think in weighing the 3553 factors, as long as the court recognizes that the verdict was guilty and takes that into consideration, how it weighs the verdict and the offense with the personal circumstances could be taken into account and can result in a lower sentence.
Thank you.
Justice Gorsuch?
Not sure I understood that last answer. I don't doubt 3553A factors are very broad and give the district judge rightly lots of discretion in sentencing when there's not a mandatory.
Teacher, they try to push them in their backs up against a wall more than
have thought that one of the
often lead them to an answer.
Personal circumstances that a judge could take into account, as Justice Sotomayor says, really nothing to do with the defendant. It has to do with the judge's own disquiet, perhaps reasonably so, about the jury's verdict. And I had thought in our legal system the jury's verdict on the facts is not something a court can impeach unless it's clearly erroneous.
That's correct, Your Honor. And what I was referring to in answering Justice Kagan is that the judge here, for example, referenced the fact that the defendant had no history of violence,
Sure.
that he was a working man, that he...
All of that's fair game. I agree with you. I'm not, again, I don't question any of that. But the appropriate remedy for disquiet about a jury verdict is to set it aside as beyond the pale. It isn't to say I disagree with the jury about the facts and therefore I'm reducing the sentence, is it?
Well, normally it isn't, but under 3582...
No, I understand your 3582 argument, but under 3553, that's not an appropriate consideration, is it?
It could be a consideration when weighing all the factors, deciding how much weight to give to questions like protecting the public from the defendant or the...
I think in that, protecting the defendant from the public, you have to take as given, again, the jury verdict. I don't think you get to impeach it by saying, I just disagree with it.
Right, but, I agree with that, Your Honor,
Okay.
but the question is how to weigh it.
Thank you.
Justice Kavanaugh?
Just one more on the role of the commission. Do you think the commission could, under 994T, say that claims of error in the conviction or sentence are not cognizable, are not extraordinary and compelling circumstances for purposes of these motions?
Yes, Your Honor. The commission has the discretion to decide what is within the meaning of the words and to take the position that certain things are off the table, yes.
And you think if they said that as to this issue, that you wouldn't be able to challenge that?
That's correct, Your Honor. District courts would have to comply with that guidance.
Thank you.
Justice Barrett? Justice Jackson?
So as I see the question presented as we've crafted it, we are not actually being asked in the context of this case to make a determination about whether a district court's disquiet or concerns about actual innocence can qualify as extraordinary or compelling circumstances. I mean, this was the exchange you just had with Justice Kavanaugh. If the commission said those things are off the table, then they'd be off the table. Instead, I read our revised question presented to be saying that anything that could possibly be raised in the context of a habeas petition is off the table. And I guess I'm a little worried about the workability of that.
So this is
when
the
we think
big
about
question
what could be raised
asked
in
here.
the context of a habeas petition.
The reason that he
Ordinarily,
used for
a habeas
changing
petition
this,
raises the claim that the defendant has the right to be released.
if this should have been brought under 2255, which is a habeas thing, can it also be brought under this other thing or not?
The judge
She just said,
the conviction
if it's under
is not
2255, does that mean we can
He
never
made
bring it
an
under
express
anything else?
Statement that he wasn't relying on any claims about the lawfulness of the conviction. He just had these other concerns. So I guess this is a long-winded question, but it worries me that we would have a rule that says anything that arises in the context of habeas can't be considered in this
Robert, that is a
proceeding, because I
whole
don't know how
conversation,
you would
something
do
I feel
that from
very,
a
very
workability
strongly about. I have
perspective.
so much information, but I can't do it right
There
now.
is a workability problem, and then there's also
That's a
the perverseness of
15-minute
having
lecture,
claims
maybe
that
10.
could not be brought in habeas would not fall within that rule, which I think is why the government went to a rule that it's only personal circumstances are allowed to be considered.
That was their way of solving my workability concern?
I think that is, Your Honor, and there's no way to read that out of the statute.
Thank you.
Thank you, counsel. Mr. Fagan?
Thank you, Mr. Chief Justice.
Okay, so
May it
this
please
is
the Court.
the
Section
Deputy Solicitor General for DOJ.
C1A1
He's going to be
is a
arguing
narrow
you can
exception to
only
sentencing
bring
finality that allows a court to reduce a valid sentence
this
in
under this
limited
habeas thing,
exceptional
2255.
circumstances that aren't otherwise
And that means you
addressed by the
can't
criminal
bring it as
justice
part of the
system.
compassionate
I think what
thing.
you've just
It
heard and
doesn't
what's in
matter
our briefs is a
if it's
proposal to
extraordinary
make
and
it
compelling
instead an
because it's
open-ended loophole
part of
to
this other thing
challenge
and it's
the
locked in
validity
there.
of sentences continuously through a potentially endless
The
series
phrase
of
is
collateral attacks on the
collateral
criminal
attacks.
judgment.
If it's a collateral
question
attack
whether
against the
a
judgment,
collateral
then that
attack on a
locks it
criminal
off into
judgment
2255. You're never
post-relief
allowed to use it.
is a question that's addressed by Section 2255, which draws a careful and deliberate line between finality and error correction. And yes, Justice Kagan, it's a
I
strict
have
line,
faded Billy, but it's
and
been a while.
ordinarily, a prisoner's claim isn't going to be compelling enough to meet it. But that doesn't mean
Spiritual
that
if
the
there's a
claim
bigger
can be wrenched out of context,
answer back in the
and although procedurally and substantively
framework.
deficient, can be used to create extraordinary and compelling circumstances that warrant reducing a valid sentence, whether or not it's window dressed with other factors that aren't themselves extraordinary and compelling reasons that warrant a sentence reduction and would be irrelevant under Section 2255. If you could do that, then it would really eradicate all the substantive, procedural, and temporal limits on Section 2255 claims and on collateral attacks on criminal judgments in general. And they say they can't find a single case in which that's happened. I think the court has one in front of it right now. It may be true that disquiet would get you, a claim of disquiet would get you nowhere under Section 2255, Justice Sotomayor, but I don't think that's to its benefit as a recycled claim under Section 3582C1A1. I'm sorry, Justice Thomas.
Mr. Fagan, there was some discussion earlier about
Condor
several
is, can you ask that again?
cases where the sentence had been reduced. Was the provision there, I think it was 4205G, is that the equivalent of the provision here, the compassionate release provision here?
It's not an equivalent, it's more like an ancestor to this particular provision. And so one big difference is that the exact language I was just referencing that requires extraordinary and compelling reasons that warrant a sentence reduction is language you'll see in the current statute and it's language from the original Sentencing Reform Act that wasn't in 4205G. But let me address the two cases that were brought up this morning. Banks is a case of rehabilitation, and that was the reason for release, and that's one thing we absolutely know for sure, and this court has several cases on this topic, that Congress was trying to cut off as a reason for release, and 994T will tell you that as well when it enacted the Sentencing Reform Act. The other case is Diaco, which was decided several years before the Sentencing Reform Act was enacted. With all due respect to the District of New Jersey, we're not 100% certain that Congress would have been aware of it. And frankly, we think it's wrong. And even then, it's a very exceptional circumstance where essentially what happened was another district judge went beyond that district judge's authority to grant relief to all the co-defendants of this one defendant, and without any other mechanism to kind of effectuate the original sentencing intent, which had gotten frustrated by ultra vires action by another district court. The district judge urged the BOP to file a motion to allow for early release on parole if the parole commission were to grant it, and the district judge in the case decided to grant it because it was, I think he viewed it as the least bad thing he could do to solve the rather unusual circumstance that came up there. But I don't think it's the camel's nose under the tent to allow legal claims. And just to answer one question you asked my friend on the other side, Justice Thomas, the word compassionate release actually is the title of the provision in the First Step Act that enacted the amendments to Section 3582C that we're talking about, to, some of which are at issue today. And I think the 2018 enactment of the First Step Act actually reinforces the original intent of Congress that this be for exceptional circumstances, not that it just be a loophole for Section 2255.
It does say exceptional circumstances, but it doesn't say solely personal circumstances. So I don't really know. I mean, I appreciate the government intuiting that, but we do have some indication that Congress was thinking beyond just personal circumstances from the legislative history. We have a case, and I'll find the case name in a moment, but in which Justice Scalia indicated that compassionate release might be available. You might know the case I'm talking about for, an unusually long sentence. So where's the personal circumstances limit?
Unusually long sentence is one of the requirements, I think.
So I think there's
we might be talking, that's the next case, sorry.
A lot of reasons to think that, Your Honor, and there's a lot packed into that question, or a few parts packed into that question. But first of all, I think the very language, extraordinary and compelling circumstances that warrant a sentence reduction,
usually not till June, but they might do it earlier.
Look at the backdrop of sentencing law. It's not extraordinary and compelling in a vacuum. It's extraordinary and compelling reasons that warrant a sentence reduction. Second, I think there's a category mismatch when we're talking about these kinds of legal claims here, because as has been noted this morning, when you raise a Section 2255 claim, you're challenging the validity of the criminal judgment. And Section 3582C1A1, we talk about this in our brief, presumes that the judgment is valid, and it's about reducing a valid sentence. And there's kind of a category mismatch with taking a reason why the sentence is invalid.
But why doesn't that cut against you? That was the point I was trying to make to your colleague on the other side, which is that to the extent these are two different things, and that compassionate release assumes a valid sentence and that you need to have or you're asking for a sentence reduction notwithstanding that, why then are we evaluating your ability to get one of those vis-a-vis what you could do in the other world where you'd be claiming that your sentence or conviction is invalid?
I think it cuts entirely in our favor, Your Honor, because it shows that these are meant for personal circumstances, because it doesn't really make any logical sense to reduce a valid sentence because of a procedurally or substantively deficient claim. The point of the claim being that the sentence was actually invalid. That is, you're taking, to use a slightly pejorative term, a kind of half-baked claim of legal error in a conviction or sentence and saying, okay, yeah, it's not quite there, but that's a reason for taking the sentence as a given and reducing it. I don't think that makes sense, and that points again toward personal circumstances.
Well, one of the things that I find perplexing about this statute is that I would have thought that this statute would have required changed circumstances. More even than personal circumstances, that it would have required changed circumstances, that's the reason for reducing a sentence. Why doesn't the statute say that, and is that what you're suggesting the statute really is all about?
I do think it is for changed circumstances, Your Honor. I think if you look at the legislative history, that's what Congress was anticipating. I think that's why the BOP filed these motions to begin with and continues to have a gatekeeper role today. I think we see that in 3582D, which are the notification requirements for the BOP, which require notifications in cases of terminal illness, which is actually kind of the canonical example that Congress was thinking of. You can look at the original Senate report for the Sentencing Reform Act at pages 55, 121, and 173, if you want some evidence of that. And I And I think we find, and the other notification circumstance would be when someone is too medically or mentally infirm to file.
I mean, there might be changed circumstances that are not personal in nature, that are in fact legal in nature. And so that there would be a divide between your personal circumstances line and the changed circumstances line. And the example I'll give you is, suppose the statutory construction, the way the courts interpret a given statute, have changed since the initial sentencing, such that somebody was sentenced to, let's say, a long sentence, and then the courts say, no, if he were coming up today, actually he wouldn't be found guilty at all. What do you do with that? Is that the kind of thing that can be taken into account under this statute?
No, Your Honor, it's not the kind of thing that can be taken into account, because that's something that's otherwise addressed in the legal system. And the court had a case about this a few years ago. It was Jones against Hendricks. And in Jones against Hendricks, the question was whether someone who had, or we didn't think he actually had a valid claim, but who had a claim that there was a statutory error in his conviction, but he'd already raised it once on 2255, could get relief under 2255. And what the court said in Jones was no, because Congress specifically thought about when someone in that situation should be able to get relief, and it allowed relief on a second or successive only for constitutional claims, not for statutory claims. Now, on their view...
Yes, so that's right. You couldn't do this by way of a 2255 motion. Gosh, it does seem as though there a safety valve would be appropriate, given that somebody is serving a lengthy sentence for something that is not a crime at all. And if we're sort of thinking of this statute as a changed circumstances statute, not as a kind of general do-over for all your claims that you could have brought way back when, but as a changed circumstances statute, that would seem to me to be potentially appropriate.
Well, Your Honor, if Congress wants to allow a remedial mechanism for that, it would be free to do so. It could add and points the Department has either proposed or at least considered proposing a new 2255H3 that would allow that. It is the kind of claim you might be able to bring on a first 2255, and it would be, provided it were brought in time. And Congress can change the limitations on 2255 that it has. But it's drawn a line between finality and error correction, and I don't think it meant for Section 3582C1A1 to be kind of a loophole for whatever...
I'm sorry.
I'm sorry, for whatever it had limitations it had imposed. Sorry, Justice Kavanaugh. That was not important enough to interrupt you.
No, it was. Could the commission do that?
Sentencing Commission.
Could the commission, under its authority under 994?
No, I mean, I think this gets a little bit...
Let me finish. Do what Justice Kagan was talking about. In other words, your answer to Justice Kagan, well, Congress could do that. My question is, could the commission, under its broad authority, under 994T,
Congress has sort of deferred this over to the Sentencing Commission.
No, we don't think that the commission in a post-Loper Bright world has the authority to make something that's not an extraordinary and compelling reason that warrants a sentence
Chevron
reduction into something that is an extraordinary and compelling reason that warrants a sentence reduction.
I don't know how Loper Bright affects that, but extraordinary and compelling are both
He's saying that
terms.
Without the Chevron doctrine, the Sentencing Commission doesn't have the power anymore.
Let me give you a longer answer to this, Your Honor, which goes probably a little bit more to the next case, but...
Courts are still allowed to listen.
It's just
they just don't have to. That's what Loper Bright said.
If these words don't cover it, then the commission can't add them. Second, the commission's required to comply with all provisions of law under 994A, and they acknowledge that. They actually accept something from their new Rule B6 because it's covered by 3582C2, and they don't think they can expand on that. But even beyond that, Your Honor, the commission doesn't have just general authority to override general provisions of sentencing law, because the Commission's role, the Commission isn't the exclusive interpreter of extraordinary and compelling circumstances.
But doesn't the
Stream
statute
titles
make
off,
them
whale.
that in some way? I mean,
I
this
couldn't-
goes
I
to a
couldn't change
question
it.
about the ordering and the steps and what the government's view is about
Exactly.
how much judges have to defer to the Commission's views on this.
That's exactly where I was going, Your Honor. So if you look at Section 3582 C1A1, you'll see that there's actually 2 threshold findings that a court needs to make before the court is going to be empowered to look at the 3553A factors and reduce the sentence. One of them is that the court has to find extraordinary and compelling circumstances, and the other one is that the court has to find that a reduction would be consistent with the policy statements of the Sentencing Commission. This court's decision in Coons against United States, I know there are 2 cases with similar names, I'm talking about the one with an S, addresses exactly identical language that appears in 3582C2 and calls it language of limitation, and I think it's even more so here, because the district court has to make an independent evaluation, even if there is a policy statement addressing it, of extraordinary and compelling circumstances.
Thank you very
and
much.
Of course, I'm sure petitioner would agree that the court has to make an independent determination of it, because otherwise, if there were no applicable policy statement, which is what the Second Circuit found in the context of petitioner's case, there would be no way to grant any sentence reductions at all, because no sentence reduction...
You'd certainly have to make an independent judgment where there were no no policy statement, but I understood petitioner to agree with Justice Kavanaugh that if there were such a policy statement, the court would have to defer to it.
Well, if there were such a policy statement, Your Honor, it wouldn't change the structure of the statute. And the structure of the statute very clearly and explicitly lays these out as 2 separate steps. So the court has to itself find extraordinary and compelling reasons, and then it has to see whether its finding or the other any of its other anything else it might do with regard to the sentence reduction. There are some additional constraints the Sentencing Commission has replaced on reductions are consistent with what the Sentencing Commission does. My point is that we know they're independent steps, and the reason that someone like petitioner was able, we think incorrectly, to get a sentence reduction even in the absence of any policy statement, that is the absence of any commission definition
It'll be up on YouTube Lives.
of what its view of extraordinary and compelling circumstances are, is that these are in fact 2 separate steps. So it's a particularly inappropriate circumstance to completely defer to the commission, because of course the commission is only telling us what it thinks are extraordinary and compelling circumstances for purposes, for purposes of limiting the statute under its own policy statements when the court gets to that second step.
On that second step, if the commission has not said that something is extraordinary and compelling, so in other words, it's been silent on it, it said other things are extraordinary and compelling, but has not said this is, would it be permissible for a district judge then to say that such reduction is consistent with the applicable policy
read what it says
statements? In
here,
other words, how do you
the
read
scrolling
the commission's silence on the particular issue?
We read it as preclusive, Your Honor. We don't think that this could be brought today under the commission's current policy statement. I mean, maybe there would be some debate about that, but I don't think I don't think there would be much. I think it's always been understood that the commission's...
And that's kind of the end of it then for this case, isn't it, under your view? I mean, that's one way, that's the end of it, which is the commission has not issued a policy statement that authorizes or that suggests something like this is extraordinary and compelling, and that's an independent requirement of the statute, and that's the end of it? Is that one of your arguments?
Well, that's not going to be the end of this case because it arose when the policy statement wasn't in effect, so we wouldn't apply the policy statement to him unless
there's never been a policy statement that authorizes this.
That's correct, Your Honor, but I don't think the court can rest on that as a potential limitation to the loophole, because as we'll get into more in the next case, there's always the possibility that the Sentencing Commission could do that. We could have another period where for some reason there isn't a policy statement, and then it becomes a free-for-all. There also is, and we think it's a quite limited one, there is a subsection B5 to the current policy statement, 1B113, which is an other reasons statement, and we could imagine prisoners correctly or not trying to, we think incorrectly, but I'm sure they would assert correctly, trying to jam in what are their recycled 2255 claims under that. And the real problem with that, and this gets to something you were discussing with Petitioner's Counsel, Justice Kagan, is what we're doing is we're taking the limitations that 2255 imposes and we're replacing them with Section 3582C1A1 considerations to make some kind of Frankenstein monster that I don't think is what Congress intended. For instance, take your example of someone who misses the filing deadline by 3 days or 3 weeks or even 3 years. And the person says, well, okay, there is a doctrine that would handle that under 2255. It's equitable tolling. Now, I can't show you any circumstances that are sufficient for equitable tolling. But what I can show you is that I've really rehabilitated in prison. So that's the reason to let me out. That is nothing but a complete end around to a Section 2255 claim. You are using the 2255 claim there as essentially the sole reason for reducing the sentence, except for rehabilitation, which is the one thing we know Congress did not want to be the reason that people are granted early release.
But I guess I'm trying to understand how your rule is workable in any real way, even with that example. So suppose you have an 80-year-old prisoner who has cancer, and I take it that your rule is that that's the kind of classic personal circumstance that can be considered in the context of compassionate release. But that could also be considered in the context of a habeas motion with respect to something like the tolling issue that you raised. So I guess I don't understand why you're saying, or how you could be saying, that anything that comes up in the context of habeas can't be ever considered in this context. And maybe I have your rule.
We're not saying anything that could ever be relevant.
Okay, so what are you saying?
So I'm not saying, like, for example, equitable tolling, like I was in a coma, that could, I suppose that might affect someone's claim of illness under Section 3582 motion. Our argument is that something that would be grounds for attacking the validity of the original criminal judgment, that is, the kind of thing that would be raised as a Section 2255 claim. This would be the claim, not just some attendant circumstance to the claim that might be used for something like equitable tolling, can't be advanced as an
even if you're not trying to
compelling
advance
reason.
it to attack your sentence in this context, even if you accept that your sentence is valid.
That's right, Your Honor, because by hypothesis, anything else the prisoner is alleging, for this question ever to make a difference, nothing else the prisoner alleges is itself going to be extraordinary and compelling enough. So what gets them over the line in these kinds of cases, in order for the question presented in this case to matter, the thing that gets them over the line has to be the Section 2255 claim. I don't think what Congress wanted was for someone to come in and have reasons that aren't enough to get him over the line. So the canonical example being rehabilitation, the court says no, and the prisoner says, well, here's my ace in the hole. It's a Section 2255 claim. Now, it would never get anywhere because it's substantively deficient and it would be wildly out of time, and I've already filed a Section 2255 motion, but hey, here's what I got, and if you add this to my rehabilitation, which is insufficient to...
Except, Mr. Fagan, what you're assuming is bad faith. Really, because, and that's not the way we function. What you want is a rule that says not only if it can be brought in or should have been brought under 2255, but even if it couldn't have but might have been, and I don't know how far your conflict articulation is going to go, then it can never be an exceptional circumstance standing alone. Well, nothing standing alone is ever an exceptional circumstance. Neither age nor medical condition standing alone qualifies you for a reduction. Does have to be extraordinary and compelling, and for that you need something more. So I understand in this case the argument that the judge's disquiet standing alone should not permit him to modify a sentence, that it had to have been with something else. And I can accept the argument that the something else wasn't much here, but you want a more absolute rule. And I fear that an absolute rule will be twisted and create its own nightmare, because there is nothing that standing alone is extraordinary and compelling.
Your Honor, that's not, the rule that we're asking for is the rule I was articulating to Justice Jackson, or at least attempting to articulate to Justice Jackson, which is that attacks on the validity of the conviction or sentence
You're
are
saying,
excluded.
no, what you're trying to say is you can't even consider it. And that's what I'm asking you, is your rule absolute that way? There are circumstances where it could be one among many factors that lead a court to a sentencing reduction, as it can be one among other factors where the court says, no, I'm not going to do it anyway.
Well, Your Honor, I think first of all, I don't think there would be any kind of nightmare, because this is the way it has worked for the entire history of Section 3582C1A1 until the First Circuit decision in, I think it was 2022. So I don't think there would be anything new. If anything, I think their rule would be very complicated and unworkable, because all of a sudden we would see any of the 5,000 prisoners
you haven't seen any of that there.
Your Honor,
I love the
rule
scare tactic, but I look for reality, and it just hasn't happened. And what I look at is the amicus who provides us with case after case where courts are taking their responsibility very seriously. They're writing 50-page, 60, 70-page opinions, analyzing cases with extreme care.
And, Your Honor, I think that's exactly the problem, because any of the 5,000 prisoners who file 2255 motions in a year could just keep bringing these same claims or new ones under 3582C1A1 and forcing district courts to respond to what are essentially new habeas.
We have plenty of ways to handle frivolous filings, counsel. We do it all the time.
The question is whether—
quickly.
I'm sorry, Your Honor. I think the question is whether Congress was trying to encourage the recycling or the renewal or the creation
What we
of
do
new—
know is that Congress was permitting sentences to be reopened. And in none of the words it's used does it put in any of the limitations that you're proposing. It does not limit this to personal circumstances, and in fact, the examples don't. It hasn't limited to only questions of fact and not law, which is what you're suggesting. It has always
Gives a lot of
included
discretion,
that there might
actually.
be other reasons, and it's permitted the Sentencing Commission to define those other reasons.
Well, Your Honor, I think there is a very strong principle. I think Prizer and other cases are an example of it, and we have some of the others in our brief, that statutory scheme should be interpreted in a harmonious whole. And I think reasons warranting a sentence reduction points to that harmonious whole.
Except,
and the idea
except our heck line of cases make very clear that 1983 and 2255
1983
are not invalid if there's a way to read
civil rights
both
claims.
where the validity of the sentence and conviction are not challenged. And here, this is not challenging the validity of the conviction or sentence. It's asking for a modification under a separate statutory authorization, but it's not challenging the validity.
But the reason for the reduction is a challenge to the validity. Even something like disquiet is, of course, questioning the validity of the original criminal judgment. And yes, that claim would not be cognizable under Section 2255 because it would be substantively deficient, because it's not even clear you can do an actual innocence claim, and if you could, it would require that no reasonable juror would find that the defendant
And the judge
is
never
not
did
guilty.
that, and under motion after motion, he denied relief, legal relief, invalidating the conviction and the sentence, but he didn't grant that. He did something totally different.
And
Thank
then,
you, Mr. Fagan.
Yeah, sorry, Your Honor. And then what he does do, and this is what we see in this case,
Stilo Frio,
is
that's a
he
complicated
eventually
question.
grants a different statutory mechanism for relief under the basis being disquiet with the verdict and sentencing disparities that are related to his disquiet with the verdict. And again, that is simply just a recycled and frankly non-cognizable Section 2255 claim. An actual innocence assertion was made on 2255 before. And there's another Section 2255 claim pending in the district court right now that makes the same assertion. I think another way to think about it, in addition to the kind of ace in the hole being a procedurally or substantively deficient attack, we'll need to wait for another day because I'm out of time, Mr. Chief Justice.
Justice Thomas, Justice Alito, Justice Sotomayor, Ms. Kagan.
So what you just said, Mr. Fagan, is one of the confusing parts of this case to me, is that when I read your brief, the formulation of the test that you offer is, could the claim of error have been raised under 2255? And I have some sympathy for why that would be an extremely relevant question, but it just does not seem to be a question that applies in this case. Because here, as you say, we've never said that an actual innocence claim could be raised under Section 2255. So sort of the premise of your argument, which is it could have been raised in 2255, sorry, you lost your chance. But the premise of the argument is it could have. And here we don't really know that it could have. The court has never said whether it could have. So the rule doesn't really seem to fit the case, if you understand what I mean.
Well, 2 points, Your Honor. You might, I think, more usefully use the formulation that it would be a claim that or an asserted reason that attacks the validity of the conviction or sentence, and I think this one would fall into that. And when we talk about Section 2255
So there is a real
claims,
difference between that formulation and the one you most often give in your
Mel,
brief. So you're now switching
scroll.
from the one you give in your brief to saying, does this attack the validity of the conviction?
well, we said both in our brief, Your Honor, and to the extent we're focusing on Section 2255 claims, I mean, frankly, that's largely as a result of the court-written question presented that we were trying to work within, which I assume kind of was written in a way the court intended to apply to this case. But the second thing I'd say is, to the extent you would include things that would attack the validity of the conviction or sentence, like a claim of disquiet, that just aren't even substantively meaningful enough to get past the first marker on Section 2255 claim, that's all the worse for prisoners in this position. So I think you would write it a bit more broadly. But I would take something. I would take this as something that could be alleged under Section 2255, and it would simply lose. I think it would make absolutely no sense to have a rule that if you could win or you could have made your
So if
claim
it
under
can't be
Section
brought under 2255 and win, like if it automatically isn't going to win.
Precluded, but if you would have had a substantively invalid claim, you wouldn't be.
Okay, thank you.
Justice Gorsuch, Justice Kavanaugh.
Just so I have the government's position clear, where does a prisoner go who has a claim of actual innocence based on newly discovered evidence?
So, as this court has explained in, among other cases, Herrera against Collins, if you have a claim of actual innocence, it's got to be paired with another constitutional claim. Now, Congress has made an exception in Section 2255.
So I think your answer there is nowhere other than a pardon.
Well, you could, if it's paired with a claim of constitutional error.
If it's not paired.
If it's not paired with a claim of constitutional error, I think it's going to have to be addressed through the clemency procedure.
Thank you.
So just to follow up on that point, Mr. Fagan, would the idea be that if an actual innocence claim, a freestanding claim, is not available under 2255, it's because Congress has implicitly precluded it by not giving a route to raise such a challenge under 2255?
Well, I think there are a couple of reasons. First, I don't think Congress has disturbed this court's. This court has never squarely addressed whether there's a freestanding claim of actual innocence, and I think if the court were to contrary to the skepticism I think the court, I read in the court's opinion in Herrera against Collins, the court were to decide that such a claim exists, I don't think Congress has precluded it under Section 2255. But if it's not an existing route to post-conviction relief, then I don't think it can be
You just contradicted
read
yourself,
into
though.
Section 2255. That is, Congress wasn't trying to create some new ground for relief. Congress did enact Section 2255H1, which kind of mirrors the actual innocence exception as a reason why someone, as a showing that a particular prisoner could make to bring a second or successive claim that would otherwise be precluded. But I don't read Section 2255H1 to authorize that kind of claim as a freestanding claim divorced from constitutional error. I think what it does is, if you can meet the actual innocence bar, it is allowing a second or successive claim that relies on some constitutional ground.
I guess I'm just trying to figure out how to articulate the rule. I mean, you offer one way. If we say that if you're going to challenge the validity of a conviction or sentence, 2255 is your option. You know, that rule I can see making sense. Otherwise, it feels like we would have to decide if we peg it to 2255 very specifically. Like, if you could bring this, if this is a cognizable claim under 2255 and you can't raise it under the compassionate release statute, it seems to me that we have to decide whether an actual innocence claim in a freestanding way is available under 2255, which I take Justice Kagan to be pressing you on.
That's why I'd go with the other formulation, Justice Barrett. And in answer to both you and Justice Kagan, if this helps, we don't really conceive of those things as being different. Section 2255 is the vehicle for raising claims or challenges to the validity of a conviction or sentence. So I think the phrase Section 2255 claim, one might think of as something that has some chance of succeeding if it's brought at the proper time. I think the right way to think about it in this context is just the type of thing that is the proper office of Section 2255. And the space that 2255 fills, the role that it fills within the sentencing scheme, is it's the place you go when you have a challenge to the validity of your conviction or sentence. That place is not 3582C1A1. There's no way that
The problem is he's saying
the
2255 is the only place you can go, but then he also said most of the time you can't bring a claim there. So
litigating claims of actual innocence under Section 3582C1A1, let alone just a mere
seemed to be Kavanaugh's problem, seems to be Barrett's problem. Barrett wants to know why he said that. Is it because Congress did that intentionally?
That argument really only works if that is the only concern in the 3582 world. I mean, what if we have the 80-year-old
And here's the
defendant who
thing.
has
So this was
cancer
multiple
and
issues, not
other
just the
ailments,
fact that he might
and
be
there's
innocent,
this concern
but he might be
about
innocent.
whether or not his conviction is valid.
There were
why would
other
the government
problems with
say
his conviction.
that couldn't be part of the overall analysis if there's more than one factor?
Well, I think there's two reasons for that, Your Honor. One is one I was suggesting earlier,
Well,
which
Sherlock,
is
in fairness,
that if you have other
doing the
claims,
job
I
he's
just
supposed to do, which is to
taking
defend
your
this
hypo, I will assume for the sake of argument that those other
we're gonna
reasons
pick it
would
apart.
not themselves be extraordinary and compelling.
Well, I mean, Congress has said in 994T, like, even when it looked at rehabilitation, it just said it can't be used alone. It took it off the table in its sole form. And I guess I just don't understand why the government isn't doing that sort of thing, as opposed to saying you can never look at it.
So I have two answers to your question,
Comstock?
Justice Jackson. I mean,
Give it a second,
the
it'll get to it
first way
again.
to look at it
It's
is
looping. It'll tell
assuming
you the whole
those
thing.
other reasons are not sufficient on their own, like you gave the 80-year-old and she has cancer. If that weren't enough on its own, then I don't think the ace in the hole can be a procedurally or substantively deficient challenge to the validity of the conviction or sentence. And the reason for that is that wouldn't warrant a sentence reduction. It's not an exceptional and compelling, it adds nothing exceptional and compelling to the mix. The second answer that I would give, which is actually what I was about to say when my red light came on, is the other way of thinking about this is a repackaged Section 2255 claim. The statute that tells us when there can be relief on a challenge to the validity of a conviction or sentence is Section 2255, and it tells us the circumstances that are relevant.
I understand. Thank you.
Thank you, counsel. A rebuttal, Mr. Groenstein?
I'd like to start by talking about a question that Justice Kagan asked, whether the government's position would be workable. And what the government's position to exclude habeas-like claims would require would be an analysis in each case of whether a claim could be brought under habeas. And what the colloquy about actual innocence shows is that that's not always an obvious question. And to the extent a petitioner under 3582 could not raise actual innocence, which seems to me like it would be the ultimate extraordinary and compelling circumstance, shows how the government gets things backwards. The government ultimately tries to deal with the unworkability problem by saying that the rule really is personal circumstances. Not only is that nowhere in the language of the statute, but clearly cases will fall through the cracks. The Setzer case is one of them, where the court considered using 3582 to deal with a state sentence that was not that was going to run consecutive. Also, of course, the cancer patient that Justice Jackson referred to. If someone had cancer and was serving a 30-year sentence and had 5 years left to live, it certainly should be relevant that the conviction that he had was no longer valid or would not be valid today. The only reason to read the statute in a way that is not according to its literal terms is if there's another statute that conflicts. The government talks about how these issues are otherwise addressed in the legal system. That is not the test. The test is whether there is an irreconcilable conflict.
One more case after
whether
this, Wes.
this reading of 3582
well,
would
it's two cases,
wholly
but they'll be heard at
frustrate
once.
the habeas statute. That's what Jones v. Hendricks was, where allowing a 2241 would entirely undermine the 2255 restrictions. As to Justice Sotomayor's point about the work that judges are doing in these sorts of cases, judges are doing very comprehensive work, and it's not surprising because this is very similar to the work judges do every day in sentencing when they are previously looked at heartland departures. They look at what makes this case extraordinary, and judges are well suited to do that, subject to to review by courts of appeals. And finally, I would, as to Justice Kavanaugh's point about the commission not speaking yet on this issue, I think it's relevant to go back to the language of the statute first, which is the words are extraordinary and compelling. They are, in Your Honor's words,
You're right,
capacious. They leave a lot of discretion.
I was waiting for
to
Comey
the
Barrett to
district
come
courts.
in.
But there's another very important
with
feature to the
questions, 'cause
statute,
it does feel right up her
which
alley.
is that there's a delegation to the Sentencing Commission to, if there are things to be taken off the table, if changed circumstances should be the touchstone. That is for the Sentencing Commission.
Thank you, counsel.
Thank you, Your Honor.
The case is submitted.
Okay, so that's case number one. All right, here's the deal, guys. Case number two it's two cases, Rutherford and Carter. It's going to be the same basic question, which is it's about this extraordinary and compelling. But in this case, what happened is these guys got really crazy long sentences because they were arrested for two things that they did at the same time. And if you got a second conviction under that statute, you got an extra 25 years added. And a little bit later, Congress changed the law to remove that. And the Sentencing Commission came in and said, look, if somebody has a really, really long sentence, they've already served 10 years of it, and a law is changed like this, where their sentence would have been way reduced by imposing it retroactively, but Congress didn't impose it retroactively, then the court can, in its discretion, use the extraordinary and compelling reason to reduce their sentence. And one of these guys had a 70-year sentence and the other had a 42-year sentence because it was an extra 25 years for two violent crimes involving a weapon. But they were both kind of at the same time. Okay, I'm going to switch the... All right, got that all out. So Congress changed the law, so that 25 years is still there, but it has to be like you got arrested, you got convicted, you got out, and then you went back and did it again. That you still get the 25 years extra for, but not if it's just two in a row. Like one of them did it within a couple of days of each other. and then got arrested later. That's no longer how you get that 25 years extra.
Next in case 24-820, Rutherford versus United States, and the consolidated case. Mr. Frederick?
Thank you, Mr. Chief Justice, and may it please the Court. The 1984 Sentencing Reform Act confirmed that district courts have broad discretion to consider relevant information in imposing and modifying criminal sentences. Section 994T limits only one category of information in compassionate release cases, rehabilitation alone. Section 3661 otherwise imposes, quote, no limitation on the information a court may receive and consider during sentencing. The Third Circuit, however, imposed a judicial limitation on compassionate release. It precluded district courts from considering a change in law that prospectively lowers sentences for offenses like Mr. Rutherford's as one fact in the total mix of information for sentence modifications. That categorical limitation should be reversed. The government concedes that age and illness are ordinary circumstances for inmates. Yet when combined with other factors, age and illness may be extraordinary and compelling in appropriate situations. Whether a change of law is ordinary, therefore, should not matter. Congress did not expressly limit that as a factor in considering modification of extremely long sentences. The Court should reject the government's contention that the 2018 First Step Act impliedly repealed the many provisions of the 1984 Act conferring broad discretion on district courts. I welcome the Court's questions.
Mr. Frederick,
No update on the
it
tariff
was
case.
Congress's choice not to make this retroactive.
Congress decided this is not going to be retroactive, but the Sentencing Commission said
as a basis or a compelling reason
you can do it anyway.
to reduce a sentence that results from the prospective nature of the law.
What Congress did in Section 403B of
This
the
is
First
David
Step Act,
Frederick,
Justice Thomas, was to apply
petitioner
it to
for
pending cases.
Squeaky.
But Congress did not speak to the question of how that
That's his
rule
name,
might apply
Squeaky.
in the 3582 situation.
Daniel Rutherford,
So
but
Congress was
Squeaky is his
silent
nickname.
with respect to that. It was, as I acknowledge, with respect to pending cases, a narrowed rule about limited retroactivity. But that just means that Congress was leaving to the individual decision-making process in these compassionate release cases up to the discretion of the judge, looking at the totality of the circumstances, whether or not the length and duration of a sentence and a disparity might be a relevant circumstance for that particular inmate. I want to point out that the government's principle here is an atextual one, as that came up in the previous argument. Its idea about personal circumstances is nowhere found in the statute, and the idea of extraordinary and compelling depends on the changed circumstances that arise after the person has been sentenced. Justice Kavanaugh, in the earlier case, you inquired about the Sentencing Commission, and I want our position to be very clear about this. The Commission has spoken to the situation that is in Mr. Rutherford and Mr. Carter's cases. If the Commission reversed its course and took those changes of law that are prospective for unusually long sentences, we would have to respect that decision, because Congress said that for a compassionate release motion, it had to be done consistent with the Commission's policy statements. So under your hypothetical, as you posed it in the previous case, we win our case. We could lose if the Commission were to change its position.
You win if Justice Thomas's point, though, doesn't make the Commission's judgment inconsistent with the statute. Now, you have an answer to that, but there's an if, I think, that goes after what you just said.
And I'm happy to provide that answer, which is that Congress didn't intend to take the Commission's discretion away when it never addressed the issue of how compassionate release motions should be treated in this gun situation when they're taking the stacking away. And it certainly has a profound effect on the one issue we know Congress wanted in compassionate release cases to be considered, length of sentence. The whole idea of compassion, obviously, is to bring compassion by lowering the amount of time that a person is incarcerated. And so it makes logical sense that if you're going to consider any legal change, it would be one where society has demonstrated a will to decrease the amount of incarceration time for persons who might be subject to that kind of principle. And that makes sense for the totality of the circumstances that a district court would be obliged to take into account in looking at the other individual circumstances that are relevant for the person. Mr. Chief Justice, you raised the question about kind of a floodgate of problems, but let me address that by saying there are three institutions that are relevant here. There's obviously the Sentencing Commission, which takes into account data and looks at real cases. There are district courts that are entrusted with dealing with these kinds of factual matters all the time. And then there is appellate review under an abuse of discretion standard. Appellate courts have exercised the reversal power under abuse of discretion where district courts have gone too far. And I would point the court to a Sixth Circuit case called United States versus Bass, in which the Sixth Circuit said the district court had gone too far in the post-COVID situation because it allowed for the reduction of a sentence of someone who had been committed to life imprisonment for committing several murders and involved in conspiracy for other violent acts. And the Sixth Circuit said that was an abuse of discretion. So our view is that although there may be some motions filed, and in the fiscal year 2025, approximately 2,000 motions for compassionate release were filed, only 56 were granted under this B6 provision. That statistic is in the clinical law professor's brief at page 17.
And is that because you think the compassionate release provision would not permit or would not make you eligible for a sentence reduction if this First Step Act disparity was the only basis? Like here, your client also alleged the COVID-19 and hypertension and obesity. Is it the plus factors that then would prevent it from becoming a huge loophole?
Justice Barrett, these are always combination of factors. No one factor, I think, arises to the level that it would by itself be extraordinary and compelling because the word reasons is in the statute. So it's got to be multiple reasons. Our client, of course, as you noted, had a very good rehabilitation record, has health issues, has family circumstances where if his earlier release would enable him to help find and provide for his deceased sister's children. So these are the kinds of circumstances that a judge reasonably would take into account.
Could a judge, let's say before the First Step Act was enacted, say that in my judgment, I really feel like these are excessively long sentences, and treat that, like the judges, let's just say it's disquiet about the legal penalty that Congress has chosen to impose. Would that be an extraordinary and compelling reason, or is it only the subsequent change?
Length of sentence is a factor, and it always has been a factor. And we know that because the Diaco case, the Bureau of Prisons, represented by the Department of Justice, came to court and said the long sentence should be reduced because of these disparate circumstances. The Senate...
Well, no, I'm just saying, just based on the judge's disagreement, you know, the judge's disagreement with the length of sentence that Congress chose to impose as a mandatory minimum.
Mandatory minimums have long been thought to fall within the
2005.
rule of compassionate release.
Booker
So has life imprisonment.
said that mandatory
and the
minimums.
Department of Justice agrees with that observation.
Oh, I guess that never
filed a
mind.
brief a couple of months ago in the Sixth
Sentencing
Circuit in a case
guidelines
called Stricker,
became
in which it took that position.
recommendations,
so that is
not
not an
required.
unusual feature
I guess
of how
laws are still
compassionate
mandatory.
release works, and that makes
Mr.
sense.
Friedrich, I'm hearing Justice Barrett's question differently, and she'll correct me if I'm wrong. I think her question is, standing alone, could a judge use their unhappiness with mandatory minimums to grant compassionate release?
That would be, I think, an abuse of discretion because the mandatory minimum set forth by statute indicates what Congress's judgment is. The extraordinary and compelling reasons are almost always plural, and in fact, the form that...
But even if it weren't plural, could the judge take disquiet or disagreement with the statutory scheme prescribed by the statute as one of the reasons?
Certainly the judge, in looking at the range of factors, would take into account that person's experience in looking at like cases to determine whether there was...
I'm just saying disagreement. You keep going to disparity. I'm just saying just disagreement. I think Congress has been too harsh here.
I think a judge is certainly not within his or her discretion to disagree with an act of Congress. Where I think that judges have addressed this particular issue and where the Sentencing Commission addressed this particular issue was to say that in the total mix of circumstances and information, it could be a factor. And it is certainly a factor that we would want to take into account because the whole idea behind this provision was as a safety valve against unusually harsh and long sentences. The length of sentence is the key fact in all of these
Mr.
situations.
Frederick, I'm not sure I understood your answer to Justice Barrett. Is it a permissible factor for a judge to include in the determination disapproval of the mandatory minimum?
A judge would be committing an abuse of discretion to disagree with a policy judgment made by Congress. However, a judge would also be within his or her discretion to say that for this particular inmate, given the circumstances here, this minimum would be subject to compassionate release.
I don't quite see the difference between those two things.
Well, the difference, Your Honor, is that we're looking at the totality of the circumstances, the person's age, how much time the person served, whether the person has health issues, and the range of rehabilitation and other family circumstances. And the court could very well say, you know, this mandatory minimum is too harsh, and because of all these other factors.
So the answer is that it can be considered, disapproval of mandatory minimums across the board can be considered in a particular case if there is something else.
I think that the part of where I'm going to challenge your question's premise a little bit, Justice Alito, if I might, is that where you say in all circumstances, because the judge is always looking at the one case before.
Okay, so there's a case where the mandatory minimum is 10 years, and the judge says, I know that's the mandatory minimum for the run of cases, but in this particular case, I think for a variety of reasons having to do, that's too long. That's okay.
Well, if your question is about original sentencing, I think that's different.
No, on this
modification.
Motion, on this modification.
If under your hypothetical, the person is 75 years old, has a life-threatening disease, and the court says, you know, this mandatory minimum is pretty harsh, and the BOP is likely to be coming back here to say we don't have the medical facilities to deal with that person, it is not an abuse of discretion for the court to say, in this particular circumstance, that mandatory minimum is too harsh.
Thank you, Counsel.
Okay.
Well, just to continue the line of questioning briefly, well, you really shouldn't call it a mandatory minimum. Then you probably should call it something like the presumptive.
I don't think they call it usually a mandatory minimum in real life. They call it a sentencing guideline.
It's not for me to offer up words to Congress that Congress
I
wrote
think.
in its statutes.
I was trying to figure this out
Justice,
yesterday.
I would say that as a practical matter, compassionate release is the rare circumstance where, as a safety valve, the court takes into account the total mix of information in determining whether a downward adjustment in the length of time that the person incarcerated should serve.
Well, in second-guessing the judgment of Congress.
Well, Congress
Gustav's
also
definitely
has delegated this authority to the Sentencing Commission, and the Sentencing Commission has issued policy statements.
You can't just be old. You have to be old and have been in jail for 30 years, I think.
Exercise their discretion in compassionate release cases to deal with the mandatory minimum concept.
Thank
and
you.
So there's law on this.
Justice Alito, anything further?
If disquiet about the mandatory minimum is a permissible factor so long as it's linked with something else, do you think there are going to be a lot of cases in which defense attorneys are going to be totally unable to come up with some other thing to link to it?
Well, Justice Alito, I would say that we do have experience with this question, that the Bureau of Prisons does have a form that the prisoner has to fill out and go through an administrative exhaustion procedure before even going to court.
Robin,
and that
70
those
or older.
factors are baked into the facts before typically a lawyer even gets involved in filing a motion for compassionate release in the district court.
Look
And district
down.
courts are free and have denied 85%
It'll
of
come back
these
around.
motions.
Justice Sotomayor?
You presented your argument slightly different than Mr. Carter's attorney, but I don't want to move away from the fundamental question here, which is this: your client's situation is consonant with the Sentencing Commission's policy statement, correct?
Yes.
And so we would have to find that the Sentencing Commission exceeded or violated the statute. Why don't we deal with that? Because they're not saying disagreement with the mandatory minimum is enough to get a change. They're putting other qualifications. Why do those qualifications count as individual?
Because they're extra-textual. The Congress made very clear in the 1984 Act, and that's why I would urge the court to consider the intent of the 1984 Congress,
Okay, Olive.
which delegated this authority to a new creation, the Sentencing
That's why it's
Commission.
there.
And it said, we want the commission to come up with an explanation for the extraordinary and compelling reasons that would underlie the inmate's compassionate release motion. And the commission, after some period of time, has done that. We now have a policy statement. That policy statement is consistent with our position.
Hold on, Dee Dee, I'll get you.
Extraordinary and compelling reasons do not have to be tied solely to the personal circumstances, although how long a person is being incarcerated is a personal circumstance for anybody who thinks about it.
There are three things.
The commission's
Dee Dee's asking why they're talking about mandatory minimums after Booker and Elaine.
It has done
think,
so.
I'm not 100% sure, but I think, first of all, mandatory minimums isn't a real term, it's just when they're using it. It should be sentencing
And
guidelines.
why is it not a violation of the statute?
It's not a violation of the statute.
The government says it is, basically.
Well, we'll hear more, I'm sure, about why the government thinks that, but it is not a violation of the statute because Congress made this delegation to the commission. It entrusted an expert agency, if you will.
Two is there's this sentencing commission who says, you know, for this crime you get this much time. For this crime you get this much time. And for 20 years, those sentencing guidelines were mandatory. They were binding, not mandatory. Booker says they're no longer mandatory. They're no longer binding. They're now just a suggestion.
Mr. Frederick, if your
Third
position
thing,
were accepted,
Congress, though, I
would
think
the
can
inquiry
still
in a
write
case
mandatory
like
minimums
yours
in the law.
look pretty similar to the compassionate release inquiry in a crack cocaine case, where
I know, child
there
loves my
is
now.
consideration of the change in law that occurred in that area.
Not necessarily. And the reason is that in the crack cocaine context, there was a retroactive application and a categorical context.
Well,
and we
Booker,
know what
I
that
think.
did to the system because the federal defenders and prosecutors had to get together to design mechanisms for informing district courts about how to deal with that. Here, because we're dealing with a changed circumstance for the gun offense, we're typically dealing with inmates who have a proclivity to do violence,
Dee Dee,
likely
the
did
bigger
do violence
problem is
in prison, violated their
this law was written in the
rehabilitation terms and
80s,
other terms of incarceration.
and then
so their
the
individual
Sentencing Commission's
circumstances, when viewed from the total
suggestions
mix,
became
are almost
mandatory,
certainly going to be
so nobody
different
was ever
in most
able to
of these
use
cases.
this law. And then it really wasn't until 2018 when there was another change that this law became actually usable. So I think we're still hashing out what it means. That's the issue. Nobody's ever really defined this term extraordinary and compelling, which I had to write behind me so I'd remember.
When Congress changes a law. But it says you cannot make that assumption with respect to our
By the way,
work in the
tap your
sentencing
screens,
guidelines
guys,
unless
and
we say
TikTok,
so
if you wouldn't mind.
expressly. That seems to have things a little bit backwards, doesn't it?
Justice Gorsuch, I would say that there are inconsistencies throughout this particular area of law that create conundrums for district courts to have to grapple with.
Well, this is a conundrum for us, I think.
I appreciate that, but what I would say is that in the particular circumstance that we have here, we are not talking about a retroactive application in any kind of guise. You can reserve on that question and say whatever the commission.
You want us to look at a change in law and assume Congress wanted us to do that, right? And the commission's saying, yeah, go ahead and do that, but don't do it with respect to our work. And that seems rather disrespectful of Congress's work and rather solicitous to its own.
What I would say in the compassionate release circumstance and that is different than the normal application of the sentencing guidelines, which are guidance to district courts in doing their sentences. And the reason why the commission would apply a rule about non-retroactivity in the initial sentencing is that it really will royal pending cases in a manner that would create more administrative burden. Our proposal here for compassionate release doesn't do that.
Well,
Awesome,
that gets back to all the questions we've already had about whether or not this opens up floodgates.
I love
guess
criminal
I'm less
procedure.
concerned about that.
I love criminal procedure.
Then again, just the solicitude that the commission shows to its own work, but not Congress, and if you could address that.
I'm not here obviously representing the commission, but what I would say is that there are administrative reasons why the commission would determine that changes in its own guidelines or policy statements would create more uncertainty in application than where you were to take an idea that with someone incarcerated like Mr. Rutherford for 42 and a half years for a sentence that should be 18 years less, you might come to a different conclusion.
Thank you.
Mrs. Kavanaugh?
Just pick up on that and Justice Thomas's original question, because the separation of powers issue concerns me here a bit, which is the First Step Act was obviously heavily negotiated and very carefully, a lot of back and forth on that, and retroactivity is, of course, always a key element of the negotiations, as it was here, when you are making a change in the criminal justice and criminal sentencing laws. And so Congress specifically, I think, says this is not going to be retroactive to those cases where sentences have already been imposed. And then the commission, though, then comes in and says we're now going to give a second look for district judges to revisit those sentences, even though Congress in those sentences did not want them made retroactive. And that seems to be, obviously the commission was very divided on this question, and the commission dissenters said this is a seismic structural change to our criminal justice system that countermands Congress's judgments.
DD, that's a much longer conversation.
That's my concern on this case, and I just want to give you an opportunity again to summarize why you don't think the commission, by doing this, is kind of countermanded Congress.
There is certainly a huge difference between a categorical application of the rule, which we know from the crack and powder cocaine context, and a more limited case-by-case totality of the circumstances inquiry where you look at the effect of the stacking of the gun charges on the length of incarceration. And I think it's reasonable to suppose that in the context where you're dealing with a categorical change that has a very large systemic effect, and amicus briefs on our side point to all the steps that had to be taken, none of those have been taken and need to be taken in the 924C context. And the reason for that, Justice Kavanaugh, is that we're looking and we're trusting district judges to look at this on a case-by-case basis to decide whether or not a sentence reduction is warranted in light of the totality of the circumstances. That kind of inquiry...
Do the disparities there worry you? Some district judges are going to treat this wildly differently than other district judges one imagines, in the same courthouse even.
I think that the disparities problem is one that ought to be concerning to reasonable people, where I think that it is an inherent part of the system of sentencing that's been part of our system for 200 years.
Fair.
It's impossible to say there's complete uniformity, and when you do, then we had our own problems with that uniformity.
Justice Barrett? Justice Jackson?
So I think you're saying in response to Justice Kavanaugh that this isn't disrespectful from the Sentencing Commission's perspective because it didn't take Congress to be removing the ability for individualized consideration in particular cases.
That's correct.
And with respect to Justice Barrett's point about how this would operate with respect to a judge who
that was the argument I was waiting
policy
for, is
disagreements with a mandatory
just
minimum.
because they changed it for the whole
I
thing
didn't take your argument in this
doesn't
case
necessarily mean they didn't
to
want
really be
occasionally a
about
judge
that
to be able to
at
make an
all.
adjustment
And
in
by
like
that
a very
I mean,
specific
I
case,
thought what
but they
you
didn't
were
necessarily want to
focusing
change
on
it for
in this
everybody.
case is the fact that there's a sentencing disparity that has been created such that your client, if he was sentenced today, would not have the same sentencing
Everybody drink.
exposure as Congress now has determined it, because Congress has changed the statute. So it's not the court saying,
I'm kidding.
I don't think people who do this
a little
sort of
early in the
thing
morning.
should be subject to this length of sentence. It was Congress
Good luck,
who
teacher.
said that in this situation, right?
That's correct. And Mr. Rutherford here served 19
Okay,
years.
so-
He falls within the policy guidance that says you have to serve for more than 10 years before you even become eligible to invoke this particular argument.
Right. So in some sense, this is giving the opportunity for a consistency with what Congress has determined about
Check in on.
what people who've done this sort of thing should get.
Yes, and doing it, though, in a contextual way that takes into account the various circumstances of that inmate's behavior in prison, age, illness, family circumstances, and the like.
And so in some sense, the compelling circumstance here is that the change, this is kind of going back to
lump
Justice
under my desk.
Kagan's point in the
Yes,
first
my law
case,
clerk.
that there's been a changed circumstance with respect to how long Congress believes that people in this circumstance should be sentenced. And even though Congress didn't necessarily want that to be applied categorically, there's nothing to preclude courts from taking that into account in an individualized way in combination with all sorts of other factors if a person requests it.
That's correct. And the 1984 Congress used the words that enabled that particular outcome, Justice Jackson. And I would just note in the original appeal, Judge Ambrose affirmed the sentence, but said it's unthinkable that in any system the sentence should be this long for the two robbery offenses that my client committed.
Can I just ask you one other thing? Because I noticed that there are differing views about the order of operations, just as a practical matter. The judge was trying to entertain a compassionate release motion. And I think it might matter because sentencing disparities are actually prescribed by Congress as a consideration in 3553A. So if you have to do 3553A, then you're going to take into account the kind of thing that the government is now saying that you don't in the extraordinary and compelling circumstances world. So what I mean is, what is your view of how this works? Lower courts, I think, are starting with the extraordinary and compelling circumstances factor with the Sentencing Commission's guidance, and then they turn to 3553A. The government seems to suggest that you start with extraordinary and compelling factor without the Sentencing Commission's guidance, then you go to 3553A, and then you consult the Sentencing Commission as a check or a limitation. But the statute suggests there's even another way of doing it, which is that you start with 3553A, and then you go to extraordinary and compelling with the Sentencing Commission. So what's your view on the order of operations in this?
Justice Jackson, I confess that it has been a while since I did sentencing cases in the government, but I would say reading this particular statute, I don't know where this 2 or 3 part step where you just start negating things if they don't meet a certain threshold. The statute is worded as if certain things happen, then such and such. And that to me suggests that this is a gestalt, it is a totality of circumstances kind of inquiry. Which order you do them in, we trust district judges to get to the right outcome based on those circumstances.
And you admit that you see that 3553A does require consideration of unwarranted sentencing disparities.
Yes.
And it's in this statute too.
Yes, and it seems odd that you would say, well, we're only going to consider it one if we've nuked you out of a position to be able to bring that argument based on considering a different factor.
Thank you.
Thank you, counsel. Mr. O'Neill?
All right, so this is the second lawyer. This is the lawyer for the other defendant, Mr. Carter, who got a 70-year sentence for robbing some banks.
I'd actually like to begin directly with Justice Gorsuch's question about the language and the carve-out that you referenced in the commission policy statement. There is very good reason for that carve-out, and it does not show disrespect for Congress. In fact, it shows the opposite. There is a separate statutory provision, Section 3582C, that specifically deals with reductions based on changed sentencing guidelines. And that requires in Section 994U specific findings that the Commission needs to undertake. So in response to public comment, during the very robust process that the Sentencing Commission undertook, the Sentencing Commission thought it was necessary to clarify how its guidance in B6 relates to that other guidance, which is set forth separately in Section 1.10. I'd also like to address, Justice Kavanaugh, your question and the one that Justice Thomas started with, because I think it is the essential argument for the government's position. Their argument is that B6 conflicts with the retroactivity provision of the First Step Act. There is no conflict. Section B6 does not purport to make that law retroactively applicable to defendants serving final sentences. Instead, it addresses a fundamentally different issue.
Joey, look
when courts
down
conduct
here.
an individualized assessment
of
a prisoner's circumstances under a separate statute, the question is, does the court have to blind itself to one factor, sentencing disparity, even though that factor may be highly relevant to the court's assigned task? We don't claim that our client could come in here under 403A and seek relief. But all that the commission instructed, all it decided is that courts may, in their discretion, take that factor into account. But it allows that only in narrow and unusual circumstances. I also think it's very important, Justice Kavanaugh, to recount how we got here, how this issue arrived with the commission and how it arrived at the court. So after Congress eliminated BOP's role as the gatekeeper in the First Step Act, courts began to address prisoner-initiated motions.
Before 2018,
Congress allowed.
prisoners couldn't bring these motions on their own. Only the Bureau of Prisons could say, we got rid of this old guy.
Should or should not factor into the equation. Divided into two camps. One camp said these should always be taken into account, and the other said they should never be taken into account. The case came here. This court denied cert after the government said this is the commission's job to address. The commission undertook that process. It was perhaps the most, the public was as interested in this issue as it had ever been in any issue. And the commission adopted a middle ground. It didn't adopt the you can always consider these. It didn't adopt the you can never consider these. It said you can consider them, but it responded to the government's concerns about administrability by putting in a 10-year bar before you could seek relief. And it required this multi-factor test that incorporates the Section 3553A factors. So in fact—
Mr. O'Neill, how long was the Sentencing Commission, how long did it consider this?
I believe that this was over about a 6-month period.
Okay. And I understand your point about, well, the commission, before it's going to make something retroactive, has certain hoops to go through. I get that point, and I appreciate that. But retroactive application of federal law also has some hoops to go through, and they're usually—
There's a little bit more, but—
we think of Congress doing those. And the evidence we have here is 403B. It says it shall apply, tells us exactly when it applies. Depending cases, okay, where no sentence has yet been imposed. And then with respect to retroactivity, it tells us it shall also apply to those drug offenses in 404B. That seems like Congress thought pretty hard about this, to Justice Kavanaugh's point. And it is a bit of a leap to say, oh, Congress didn't think about this, and retroactivity of a criminal law in a sentence, it just failed to consider it. It seems a plausible possibility, but perhaps a little disrespectful.
No.
I think the counter-argument is that they just didn't want it to apply to everybody.
In 403 was applicability to everybody.
There we go.
So does it apply to everybody moving forward, and does it apply to everybody moving back? Retroactivity would have meant that every defendant who had committed an offense before the act would have received—
pretty clearly ruled out, right?
We agree that is ruled out.
Okay.
Mr. Carter, because he is not in that class, he cannot claim relief under Section 403A. But Congress said nothing about whether the impact of those changes could be considered in the context of an entirely separate statute.
I understand that, and so we're having to draw an inference, but boy, Congress spoke pretty clearly to retroactivity in 403 and 404.
I would stick to that line.
Of course, I make 2 points. First, even the government agrees that these changes actually can be taken into account even for defendants serving final sentences. So the government agrees that when you get to what it calls the sentencing determining phase in this two-part stage that it imagines, that the court can take into account how the 403 changes affect the calculus. So that blows a hole in their idea that that Congress never wanted these changes to have any effect on final sentences.
And you can take it into account because the statute says so, right? Is the government's view that you can take it into account because this statute requires the court to refer to 3553A, and 3553A says sentencing disparities have to be taken into account?
That's exactly right.
It's
The other point I would make,
disrespectful in theory,
Justice
DD,
Gorsuch,
because
and
we
it's baked into
assume
your
that if they
questions,
didn't
this
write
is an
something there,
inference.
they did that
It
on
is an
purpose.
inference from congressional silence. And all of the government's arguments ultimately rest on trying to find implied limitations from congressional silence. The government wants to infer, and it's not just an implied limitation, it wants to infer a categorical bar against consideration of this fact, the fact of sentencing disparity. And it wants to infer not just a categorical bar on that factor, but a categorical bar on that factor ever entering into the equation, even though, in combination with other factors or alone, even though Congress didn't do that when it identified a specific factor, rehabilitation, as one that's off limits. That is a lot of meaning and content to read into congressional silence. There are at least 5 statutory rules of construction here that counsel against exactly that inferred limitation. The first is the most basic one, that this court does not lightly assume that Congress omitted from statutes text that it meant to apply. That's
the thing. You always assume that they thought this through. To assume that they just didn't think of it, they're saying would be disrespectful.
You don't infer another one.
Disrespectful to Congress.
The third is the rule from Kimbrough. We're dealing with the sentencing statute. Congress has said, this court has said Congress knows how to direct sentencing practices in express terms and has shown that it has done so. The fourth is the Concepcion principle. You start with the premise that Congress meant district courts to have the broadest possible discretion unless the Constitution or Congress explicitly limits it. It hasn't done so here. And then finally you add on top of that, because you have an express delegation to an agency or here to the commission, Justice Thomas, your opinion in Little
Sometimes
Sisters
that's
of
the
Poor
question,
made
Robin,
clear that
whether
there
or
is
not
that kind of clear and express
Congress is right or
delegation,
wrong, but not always.
You rewrite the statute, you don't apply it if you start inferring limitations.
Actually, a
on that
lot of the
discretion
time,
that
that's not what it
Congress
is. It's,
did not apply.
is this what Congress said or
I will
not?
just make one more point about the scope of the commission's discretion, because Justice Kavanaugh, I think you got that
This is
exactly
live.
right in the first argument today. This
Sorry, I
case
had the
is much
date.
simpler.
The date on the
Because
bottom is
Congress
screwed up. Sorry,
gave
I can't
the
change it. I don't have
commission
access to it. I
responsibility describe
apologize.
What should be considered extraordinary and compelling factors? The commission has done that. So the question in this case is very simple and straightforward, and the question is just,
Yeah.
did the commission's policy
I just said your
statement
name so you knew I was
B6,
talking to you now.
Is that a valid
It just
exercise
happened to
of
come up.
expressly delegated authority?
When you said middle ground earlier, you were really focusing, I think, on the 10-year point. Is that accurate?
It's not just the 10-year point. When the commission first took this issue, it was urged to adopt a provision that would have said whenever changes are inequitable in light of changes of the law, that would have allowed it. It didn't adopt that provision.
Do you think they could have adopted that?
I think that probably would have been within the scope of the commission's discretion. But I'd like to make 2 points about the government's parade of horribles here. The first is, there's nothing in the commission's history or its composition that would suggest it's going to adopt anything like the kinds of proposals that the government fears. In fact, the commission's history is that it has been quite cautious, not cavalier, about the use of this power. If it did adopt any of those outlandish proposals, the guidance has to go in front of Congress for 6 months before it goes into effect, and Congress could reject it during that time, as Congress has done with previous.
That's a
commission
good
guidance.
argument.
And then the second
If it
point
was
is
already in front of Congress
the
and they
fact
didn't
that
reject it,
the
then
commission could have gone farther, but chose not to do so.
Chino,
simply shows the
the
modesty
scroll.
and care with which it undertook this task.
Thank you, Counsel. Justice Thomas, anything further? Justice Alito?
What do you think are the limits on how far the commission could go?
The commission cannot violate a specific directive of Congress. The commission needs to adopt purposes or reasons that are grounded in the purposes of sentencing. That's section 994A2. The commission's interpretation.
What relevant, what fact, you said it can't contradict a specific direction from Congress. Which specific directions would limit it?
Well, for example, if the commission were to say that rehabilitation alone were an adequate factor.
What beyond that?
There were questions earlier about whether the commission could say, you district court may disagree as a matter of principle with mandatory minimums. And we would say that that would be a violation of the specific directive of Congress, that is a reasonable punishment for that offense.
Well, is there a provision that says specifically?
So that's interesting. The two judges,
not do that?
The two defendant attorneys disagree on that point.
There is a provision
clearly
that it's general principle that the commission obviously can't violate.
Inference, isn't it? It's an inference from the imposition of a mandatory minimum, right? That was what it would be based on.
No, that would be based on the fact that Congress said you may sentence someone to this offense. If the commission said, district court, you may take your own disagreement with Congress about that as a policy matter, not in the context of the specific case or the circumstances of the prisoner's overall situation, that would be in conflict with an act of Congress.
I'm not sure I understood that. What is the difference between the inference that one would draw from a provision that imposes a mandatory minimum, namely that Congress did not want that to be disregarded in any case, and the inference that one might draw from a provision that says this change in the law will apply retroactively to this limited class of cases but no other? What is the difference between those two inferences?
The difference is the latter does not take into account all of the circumstances that warrant relief in the prisoner's particular case. B6 is all about the individual circumstances, whether in context the sentence is unusually long, whether it creates a gross disparity, whether the circumstances warrant it. The one that you hypothesized is an across-the-board, non-contextual rule that Congress can never consider.
All right, thank you.
Killed another notebook.
Then I don't understand your answer to Justice Kavanaugh.
I hope there's another
You
one here.
said that if the commission said every prisoner is entitled to compassionate release because of the mandatory minimum, the whatever, that's okay, that's within their power.
No, I think I was answering a different question.
How did you because I understood your answer to him, that if the commission had taken what was the extreme position some people had proposed,
even
that the mere change in law was enough, that's okay.
Thank you, Justice Sotomayor. What even that more extreme position would have required an evaluation of the...
Yeah, but why wouldn't it be itself an abuse of discretion? I'm very surprised at your answer to him, because it seems to me that the logic of your answer on the mandatory minimum is that if they do something so extreme as to ignore that Congress has not made this retroactive to all prisoners, why isn't that equally an abuse of discretion?
Because the proposal that I was addressing, the inequitable in light of changes in the law, that incorporated individualized considerations. What I took the question to be asking about was an across-the-board, non-contextual rule that a district court may simply disagree with the policy of a mandatory minimum and treat that as an extraordinary and compelling reason. And that was Justice Alito's question. What I said in response to Justice Kavanaugh was that the commission could have adopted a rule that didn't have all of the limitations that B6 ultimately adopted, and simply said that...
I don't understand that they had to have some limitations, according to you.
Right.
They had to list some individual factors, correct?
That's correct. That's correct. And even that proposal would have been based on the particular circumstances of the prisoner's condition and
so
circumstances.
we're talking past each other. We're not talking about you arguing that they can say this always constitutes a reason for compassionate.
We believe that a rule
Standing alone.
Standing alone, exactly. We believe standing alone that would be coming very close to trying to treat 403A as retroactive, and we concede that that is further than the commission could go.
Justice Kagan?
Mr. O'Neill, same question that I asked Mr. Frederick. If your position is right, does the inquiry into sentence disparities in these gun cases start to look a lot like the inquiry into sentencing disparity in the crack cocaine cases? And if it does, is that odd given the textual difference between Section 403 and Section 404?
The analysis is completely different between the crack cocaine cases and the kind that are covered in B6. The federal defender's brief does an excellent job of explaining how different these procedures are. With 404, which was an actually retroactive law, district courts set up standing orders. Defendants were waived through because there was no question at the eligibility. It was all about the 3553A factors. Here, every case is considered on its individual facts. The courts exhaustively look at the prisoner's individual circumstances, and the statistics bear out this difference. So during the time that, as Mr. Frederick said, I think there have been 150 grants in total under B6. During that time, under 404 and the crack cocaine cases, there were 4,000. And that is a demonstration of how different these regimes are.
Thanks.
Justice Gorsuch, Justice Kavanaugh, Justice Barrett, Justice Jackson. Thank you, counsel.
Thanks very much.
All right, now we're on to lawyer number 3. To answer your question,
Mr. Fagan?
Thank you,
I'm happy
Mr.
to break
Chief
down what I
Justice,
can.
and
It usually takes me a while to process some of this
The
too.
core of the sentence reduction motions the petitioners are making in these cases.
So this is Eric
that
Fagan
they
again, the
have
guy who
received lower sentences if they were
represented the government in the
sentenced
first
after the
question,
Step
or the
Act's
first
changes
case, if you were here for
to
that.
Section 924C.
If you guys
In
could, by the way,
enacting those
tap.
very changes,
If anybody wants to
Congress made a
subscribe in
categorical
TikTok, please
judgment
do, or
to,
become a member in
in the
YouTube.
words
I
of
would
the
appreciate it.
principal opinion in Hewitt,
And
leave Section 1924C offenders with final sentences stuck with their old sentences. That categorical judgment can't be leveraged into extraordinary and compelling reasons that warrant reduction in petitioners' lawful, indeed legally mandated sentences. This Section 3582C1A1 isn't a license for either individual judges or the Sentencing Commission to create what's effectively a new form of judicial parole, where someone who does not have extraordinary and compelling reasons warranting a sentence reduction can suddenly claim that they do in light of an expressly non-retroactive change in the law. Now, I think that's exactly what the Commission's done here. So to respond to the suggestion that this is a moderate middle ground solution, it is anything but a moderate middle ground solution, because as to 924C offenders, which were top of mind when this was adopted, it includes basically everybody. Take the 10-year limitation. The minimum sentence for a stacked 924C offender is going to be 30 years, 5 for the first mandatory minimum and 25 for the consecutive. That could be characterized, the difference between that and, say, a 10-year sentence under the new regime could easily be characterized as a gross disparity. And then we are down to, I think, basically just the individualized circumstances. And then we have judicial parole. If I may have one more second, if you listen to the reasons that Mr. Frederick gave for letting his client out, family circumstances and rehabilitation, that would be exactly the kind of reason that would have gotten you out on parole. I'm sorry, Justice Thomas, and thank you.
What limits would you put on the Commission's authority to describe what a compelling interest is, or what an extraordinary circumstance is?
Well, I don't think that they can simply disagree with Congress or authorize individual judges to
can they do that?
Congress.
What I'm hearing is that in standing alone, they cannot disagree with Congress. That's what I'm hearing from the other side. But if it's a part of a totality of the circumstances inquiry, then they can disagree with Congress.
And I think the fundamental problem with that, Justice Thomas, is exactly what I just said, which is that it's a form of judicial parole. If you think back to what I said in the last case, essentially we are taking as a given that the other circumstances, the other reasons, are not in themselves something that would warrant a sentence reduction. They're not extraordinary and compelling enough. What gets them over the line is the fact that Congress adopted a non-retroactive change in law that it explicitly decided not to apply to prisoners in their circumstances, and that is what gets them consideration of these other factors that wouldn't be enough on their own.
So what do you say
He doesn't seem to answer the question,
that it's
I
not
don't know why.
necessarily a direct attack, a disagreement with Congress, but rather the effects of the provision, the, say, for example, non-retroactivity?
Well, I think this is a direct attack on what Congress did because Congress drew a categorical line, and as the principal opinion in Hewitt recognized, that was partly to prevent all the relitigation concerns. I think the fact that, as my opponents acknowledge, these are even more burdensome to litigate than Section 404 adjustments to sentences, which Congress expressly did make retroactive, is a strike against it. When Congress makes categorical judgments and it wants to allow for exceptions in individualized circumstances, it will enact something like the safety valve, which for mandatory minimums, which it again adjusted. That's in Section 402 of the First Step Act. And here you have what the Sentencing Commission in 2021 estimated was 2,412 offenders with stacked 924C sentences who'd be affected if this became retroactive. And as I was just suggesting earlier, this is essentially a full retroactivity provision in the sense that it opens the door to things that were not extraordinary and compelling reasons suddenly crossing that threshold.
So, Mr. Fagan, you've said that a couple of times, and that I don't know that that's actually consistent with how this works in real life. In other words, you set up your argument both in the prior case and in this one to suggest that the court is marching in seriatim through these various criteria, and it starts with age and it says, this is not extraordinary and compelling enough. Let me add illness. Oh, let me add, sentencing disparity. And that things that previously would not be enough to get them over the line suddenly become so when you add in this other factor. My understanding through conception and also experience is that that's not exactly how it works. The court is looking at the totality of the circumstances. It doesn't necessarily go through and determine whether each individual criteria itself is an extraordinary and compelling circumstance. So, for example, age would never be. I mean, that's not extraordinary. Everybody gets old. So it's not really doing an individualized tick off the box for each criteria, and therefore it becomes problematic when we look at something like sentencing disparity. So if I reject that characterization of how it works, do you lose?
Well, Your Honor, first of all,
I got to point out real fast, guys, that he just said my opponent, which is very weird. Usually they always call each other my friend. It's very rare for them to say anything else. Not something you do.
Compelling circumstances become so by adding in this, and that's the problem.
So think of it this way, Justice Jackson. It's as though you are weighing something and it has to weigh enough. It has to be.
But I'm telling you, if I reject that characterization, you're starting with the empty scale and you're putting all the things on, not one at a time and seeing whether or not each thing gets you across the line.
Your Honor, you're not necessarily doing it one at a time, but I think even they would acknowledge that their claim is that they are not making the claim that if the question presented didn't matter, that is, if this were not a valid consideration, they would be eligible for relief.
They're saying you should not restrict the district court from doing a totality of the circumstances analysis that takes into account all of the circumstances. That the way you're setting this up, you're suggesting that certain circumstances should be left out because they're inappropriate, And in that case, you know, the court should not have any ability to consider them. And what I guess I'm suggesting is that we all seem to agree that this is a totality of the circumstances. And so why can't the court take this sort of thing into account, especially in this case where Congress has made a policy determination that indicates that creates a sentencing disparity and indicates that this is a really unfair circumstance?
Well, I guess 2 points to that, Your Honor. It's not phrased as a totality of the circumstances as such. It's extraordinary and compelling reasons that warrant a sentence reduction. And so you have to consider whether something that is being put on the table.
But they haven't defined it. That's the problem.
Contribute to that inquiry. I guess the second point, which builds on the first, is if you have a mix, and you don't have to like tease it out into individualized reasons necessarily.
I guess maladaptive.
But if you
it's
have
just
a mix that is not going to be sufficient,
trying to think of the right
other
word.
reasons that Mr. Frederick mentioned this morning.
The decorum of the Supreme Court is that you call the other person my friend.
I think their claim in this case, the only way they can succeed in this case is if they are allowed to add this additional factor to the mix. Now, the upshot of adding that additional factor is they're adding something that is manifestly not extraordinary and not compelling because it is the normal operation, and here the express operation, of non-retroactivity law.
Sorry, go ahead and finish.
Oh, and it also, again, I hate to keep repeating
Here comes
myself,
Barrett.
but I think it's a point worth really driving home yet again. It's effectively, if you think about it on the flip side of the coin, creating judicial parole by unlocking the door to things that would not be extraordinary and compelling if that consideration were not on the table, and all of a sudden they can become a reason for release.
It's weird.
Thank you for your patience.
I just wanted to ask you about your Loper-Bright point and the degree of discretion that
That's
the Sentencing Commission has here. I'm going to state it, and then you tell me if I'm understanding your point correctly. You don't dispute, Justice Kavanaugh pointed out that the terms extraordinary and compelling are capacious terms. And so the Sentencing Commission does have some discretion within words like that to enact policy statements. Right, just
correct.
Okay, I'm getting to the point I think that you want me to. Your point about Loper-Bright is that discretion has to happen between certain goalposts, and the fact that the First Step Act has imposed a rule of non-retroactivity means that the Commission has exceeded the limits on its authority. So it's not that it doesn't have a lot of discretion, but here it's bumped beyond that.
That's exactly right, Justice Barrett. And I think one problem with their position, and I think it's been well illustrated in the other arguments in this case this morning, is there's really no limiting principle to what they're saying the Commission could do. They are.
You just said you argued the other one. You just said I argued my own thing well.
I'm confused as to what their answer is to the hypothetical where the Commission just decides to allow courts to disagree with mandatory minimums.
Read that.
I think the reason they're not giving you a clear answer that the Commission couldn't do that is because it logically torpedoes their argument. Because in their view, the Commission can say anything it wants as long as it hasn't expressly precluded sentence reductions. But of course, a mandatory minimum, like the one in 924C, just says the defendant, if you look at the language there, that it just says the defendant shall be sentenced to a term of no less than 5 years.
So define the goalposts for me. I mean, you're saying they've gone past some goalposts, but Congress has not said anywhere, you, Commission, can't look at non-retroactive changes in law. It hasn't said you can't look at changes in mandatory minimum. It hasn't said, the only thing you can't look at alone, it said, is rehabilitation. That's the only limitation Congress has said.
Well, it has said, Your Honor, under 994A that the Commission's policy statements have to be consistent with law. As for rehabilitation...
Well, there is no law that says that. There's no law that limits what they can consider.
Well, Your Honor, I think even... I'm sorry.
And 353, 3553A, thank you, I'm tongue-tied on that one, does permit courts to look at disparity with co-defendants or with others. So I don't know where you're defining that the goalpost is defined by something that's not specified in law?
So let me tease that out a little bit. I think they're not trying just to look at, there are a few points. Number one is the colloquy I was having with Justice Kavanaugh in the first case about why the 3553A factors aren't the relevant consideration at this part of the inquiry. But even beyond that, they're not just looking at disparities alone. They're looking at disparities with offenders who were sentenced under a non-retroactive law that applied to them but didn't apply to these offenders. And I think even my friends on the other side would have to agree that you can draw some implicit lessons from Congress's enactments. To get to Justice Gorsuch's questions, that's exactly why the Commission would claim that it has exempted its own non-retroactive amendments from its policy statement. It's because it believes that if it didn't do that, it would be overriding the limitations in 3582C2. And if it can't override 3582C2, I don't understand why it can override Section 403B of the First Step Act. Essentially, what they're saying is that because none of these statutes expressly speak to sentence reductions, I guess 3582C2 does to some degree, but it doesn't expressly preclude the use of 3582C1A1 when there are other circumstances involved. Because they don't expressly speak to sentence reductions, they are automatically possibly on the table. And if that's true, then there are substantial separation of powers concerns, because then they essentially have the pen on sentencing law. Now, if I could address rehabilitation for a second, Justice Sotomayor, I think there are a couple of points. One is rehabilitation is something that I think could otherwise have been considered an extraordinary and compelling reason. I think there are examples of many prisoners who would claim that they have extraordinary and compelling stories of rehabilitation. One thing that they're able to do under their position is just to take that rehabilitation, combine it with a non-retroactive change in law, something we know Congress didn't want to apply to these kinds of offenders.
So do you think that someone who has rehabilitated, been in jail for 40 years, let's say, and is now 90 years old, and they have spent most of their life in prison, could not have a claim for compassionate release if they come in and said, I'm 90 years old, I'm going to die soon, because rarely do you last very long after 90. The chances are very slim. And now there's been a change in law. I can't qualify under your reading of this.
So, Your Honor, in the absence of B6, even the Commission wouldn't allow release under those circumstances, because it's not age as such. It's limited, I think it's B2 is limited to age-related.
So your answer is that wouldn't be enough?
I think it might be within the...
And there, I didn't add that there was a change in law, all right? Because that's what's at issue here.
So, Your Honor, I think that those may not be extraordinary and compelling on their own. If they were extraordinary and compelling on their own, we wouldn't have, this question wouldn't ever come up. The other problem with 994T, I think, that's a real problem for them, is they don't if they want to follow the expressio unius principle from the consideration of you can't consider just rehabilitation alone to its logical conclusion, then I don't see how they're able to maintain their position. What 994T says about rehabilitation is that it's a consideration that can be considered in conjunction with other factors, but not on its own. But that seems to be exactly how they're treating non-retroactive changes in law as well. So if they think 994T is something that says only rehabilitation can be treated in a particular way, they're violating their own principle. I think 994T is just about limiting consideration of that one principle. If they instead think that non-retroactive changes in law can on their own be reasons why someone could get a sentence reduction, then I think there are even further problems with their position. But under their position, the Sentencing Commission could, in theory, come out with a rule that allows district courts simply to disagree with mandatory minimums. And then, as we specify in our brief, the district court says at sentencing, well, you don't qualify for the safety valve. Unfortunately, Even though I'd rather not, I'm forced to sentence you to this mandatory minimum, but I'd be very open to a compassionate release motion. The prisoner files one the next day, he waits 30 days, and the district court, because the BOP is not going to endorse it, and then 30 days later, the district court's able to reduce the sentence. That cannot be the way this works. Yet if they say that that can't happen, that that's somehow some kind of abuse of discretion, that the commission doesn't have that authority, then I don't see how they have the authority they're asserting here.
Their theory is that that is a direct conflict with Congress's statement in the statute that this is our policy choice with respect to what kind of sentence applies in this circumstance. And what I take them to be saying, and this is, I think, a really legitimate question, is do we have that same kind of conflict here? You suggest, and I think the linchpin of your argument is that Congress's determination not to make this retroactive is a statement that Congress did not want anybody who was already serving these sentences to benefit from this sentence reduction. But I think there's also the possibility that instead of that inference being drawn from the retroactivity determination, there's the inference that Congress did not want to impose all of the administrative burdens that would apply or that would arise if there was categorical application of this to everyone without, the way in which retroactivity works. If we believe that that's what Congress was saying, that's what Congress was saying when it said no retroactivity, there isn't a conflict with a circumstance in which you look at 3553A and you look at 3582, the compassionate release, and take into account something like sentencing disparity.
Well, Your Honor, I think it's difficult to look at 403B, particularly in context where Congress did enact other retroactivity mechanisms, and plainly did so because in the entire interregnum period between the Fair Sentencing Act and the enactment of Section 404, which made the Fair Sentencing Act of 2010's changes for crack cocaine offenders retroactive. And during that entire 8-year period, no one ever thought that Section 3582C1A1 could do work for at least some subset of those offenders. I think it's a little difficult to look at 403B in that context and see it as anything other than as a policy judgment to leave offenders who had final sentences stuck with their old sentence.
What do we do with the fact that Congress did not speak to its directive in the compassionate release scenario, that you look as a judge to 3553A, which allows for consideration of sentencing disparities? It seems to me that if you're right, Congress would have needed to amend the compassionate release statute, either within the statute itself or taking out 3553A or addressing it like it did in 994T to take sentencing reductions out of it.
I don't think so, Your Honor. I think that's imposing kind of a clear statement rule on Congress to exclude particular enactments of law from the operation of 3582C1A1. It certainly didn't do so in 924C itself in saying a defendant shall be sentenced to a particular offense. And to your earlier point about administrative burdens, I think what Congress would have been creating if it allowed for this kind of judicial parole system is an even greater administrative burden on the courts, because what it's reenacting is exactly what we had pre-Sentencing Reform Act, where there's kind of a forced rehabilitation scheme. We talked about this a little bit in our brief in RICO, the case the court heard last Monday, where offenders think that, prisoners think that they need to rehabilitate, and that's how they're going to get out, and so they work to rehabilitate. And 5 years from now, we'll see each of these 2,412 affected 924C offenders, to the extent they haven't already been let out, claim rehabilitation. And if that fails, they'll file another one a couple years after that. And I don't think that's the scheme that Congress was creating, which is even more burdensome than some of the streamlined schemes that were developed under Section 404.
Why did Congress distinguish, do you think, or do you know, the crack offense retroactivity from the 924C offense retroactivity?
Well, the crack offense retroactivity was actually making up for not a loophole, but a problem it perceived after the Fair Sentencing Act, where as the court discussed in Dorsey, it had made the changes effective from that day forward, essentially exactly what Congress then decided to do in 403B, and was making up for that for the set of prisoners who were still in prison for those offenses. I think actually the fact that Congress was deliberately doing that is, truing up offenders where it had enacted
the thing
a 403B
that came up a minute ago is
and at
when
the same
Yvette
time
said,
enacting 403B.
People should stick,
really
be stuck with whatever sentence they get. That is a
Congress
policy
could not
question.
have
What's a
meant to
good
be
idea? What's a
allowing
bad
the
idea?
kind of thing
That sort of
that
thing. And
petitioners
those
say they're
decisions are
allowing
made
here.
by
Nor would
Congress.
it just be 403B,
The court is trying to decide
because
what
Section 401
what decision
of the
did
First
Congress
Step
make
Act,
when
made
they
some further changes
balanced
to
those
the
questions of
drug
what the best
sentencing,
idea was.
Provisions of
What did they
21
decide?
USC
Because the laws are
841,
often
changing the
the
nature
law
of the
says
predicates. And
anything
for
extraordinary and
that, there
compelling
is a
is fine, but they didn't
401B
define
that looks
extraordinary and
exactly
compelling.
like
What does it mean?
403B.
That's what the
And
court's
there's
trying to do
another,
now.
the
So it's not up to them whether
commission
it's a good idea or a bad idea, but just trying to figure out
3,742
what they
offenders
meant.
would be affected by that. So to the extent they're still in prison, it would be opening the door to sentence reduction motions by them.
Yeah.
There's another level
That's why we
of
elect the
problem
people
here,
who
which
balance
is,
those things.
that
Those people are
it-
sent by
the
us. The
Commission's
judges
Rule
we don't
B6
elect
also
because
purports to
if
authorize
we don't like their
reliance on
answers,
other non-retroactive
that's not the point.
changes in law. So we will get things like, and are getting things like claims under
language is
Booker,
ambiguous.
United States against Booker, which is non-retroactive about the changes to the guidelines, the advisory guidelines, and any all sorts of other claims about non-retroactive changes in law. So you will get some kinds of things that would have been a problem, that would exhibit the sorts of problems I was mentioning in the last case, where something has to be retroactive in order to qualify as a valid Section 2255 claim. I mean, it's
Can I
an
just
overused...
ask you one more thing about the commission?
Yeah.
How is it that the commission is way out of line in a situation in which the courts were deeply split on this issue to begin with before the commission even entered?
Well, Your Honor, I don't think the mere fact that the courts were split reflected that the commission could resolve that reasonable policy disagreement, because as we...
So you're saying the commission had to choose, it had to pick.
Well,
either
as we
you can never use it or you can always use it, because that was the split.
As we expressly told the courts, like once this and is the Third Circuit recognized in this case, once one of the courts, the 6 courts that went in our favor as opposed to the 4 that didn't, I mean, once they agree with us that this is not a valid consideration under the statute, the commission doesn't have the authority to adopt under the statute. And this is also what the 3 dissenting commissioners said. The commission doesn't have the authority to adopt under the statute something that the statute doesn't in the first place allow.
That just means you disagree with the commission's statutory reading. I guess I'm just trying to understand why it's unreasonable, given that some courts agreed or thought that it was okay under the statute. The commission just, it seems to me the commission agreed with the courts that didn't agree with you, said it was okay under the statute, but only under these limited circumstances. Why is that just completely an abuse of the commission's authority?
I mean, to put brass tacks to it, Your Honor, the 4 courts that thought this was permissible under the statute are wrong. And it's not just it's not resolving some sort of, you know, you could do it one way, you could do it another way kind of disagreement between the courts of appeals. If you can't do it under the statute, which is what the majority of courts had said, then the commission can't do it either, and they can't do it in a purportedly limited way that, as I've mentioned earlier, is not particularly limited. But
okay, in fairness, this is his second case this morning. He might be a little worn down.
Kind of homily that Congress doesn't hide elephants in mouse holes, but this is a pretty big elephant to have hidden in this mouse hole. For Congress to have done with Section 3582C1A1
I'm going to give him the benefit of the doubt on that.
I don't think there's any evidence in the history, any evidence in the context that that's what Congress was directing these things at. I think this applies to both the cases this morning, both Section 2255 claims and non-retroactive changes in law. There are often cases in which Congress decides to ameliorate sentences going forward. The court has described those as perfectly ordinary decisions by Congress. It's also the ordinary business of the courts
extraordinary.
To reinterpret statutes, which can also be non-retroactive, particularly where they're just dealing with procedural matters. And I don't think Congress was opening the door up for those kinds of claims either. Even if a lot of these claims are going to be rejected, they are quite burdensome on courts. That's true in the 2255 context, where you've essentially got new habeas motions or post-conviction motions.
I was thinking that during his first argument, like,
oh,
I gotta listen to another hour.
In this case, where the court has to go through the individualized circumstances of each defendant and try to combine all the apples and oranges to figure out whether this particular prisoner is deserving of relief.
So ZZ Dot, the answer
is that there's neither an elephant nor a mouse hole here.
When you interpret law, you always assume that Congress thought everything through.
Of sentencing modification proceedings.
Not necessarily sensible, but that's just sort of the rule that we start with when we interpret, because we got to start somewhere.
And then not an elephant in the following way.
It's like
I mean,
a
what
basic
you're
rule
saying
of interpretation.
is that when Congress set up a rule that says this statute should apply prospectively, not retroactively, Congress must have meant with respect to everybody in all circumstances.
Oh, yeah.
And that seems,
that guy's voice.
I think I'm going to make you repeat your argument about why that's true. Because if we take it as a given that the Sentencing Commission could not say, of course, if you come in the sentencing proceeding, we'll give you relief no matter what. All you have to do is point to a sentencing disparity. Then I might say, okay, now you have an elephant problem. But that's not what the Sentencing Commission did. The Sentencing Commission set
if you haven't subscribed,
criteria,
consider subscribing. It
and
helps
then
keep
on
me
top
doing
of
this
that,
stuff.
said only given all the surrounding circumstances of your case.
It's supposed to tell me if
what the
somebody subscribes,
Sentencing Commission did was to say, we're respecting the rule that Congress has set up, but the rule that Congress set up is a categorical one that doesn't ask us to say within an individual case that the sentencing disparity can have no weight at all.
Well, let me address the mouse hole and the elephant point separately. As to the mouse hole point, I think we did have a mouse hole here because neither they nor any of their amici nor any of the parties or amici in the previous case have ever pointed to a single instance of Section 3582C1A1 ever being used for these kinds of legal changes that they're pointing to in these set of cases. I don't think Congress had any reason to anticipate that this was an option on the table. And I realize I apologize.
Why don't you finish and then we won't.
I'm sorry.
So as a general rule, you start with the assumption that what's written there is all intentional, and then you move from there.
As to the elephant, Your Honor, I do think that this would be authorizing quite a lot, because I think there's been a lot of focus on what's going to get granted and what isn't. I think there are a lot of motions that are going to get granted. It's not a huge and significant difference, but we are seeing higher percentages of grants in the circuits that do allow consideration of non-retroactive changes in law. I think we have every reason to believe that that could increase in the future as prisoners decide to build up some kind of record that might suggest rehabilitation and then force the courts to evaluate whether they have done enough. There is absolutely no time limit or numerical limit on the number of these motions that we will see.
Thank you, counsel.
There are a ton of old rules, very old rules, some of them ancient, like Greek, called the canons of construction, which are the rules that we use to interpret. And we assume that they're the same rules that were used when they wrote the laws. And there are lawyers hired by Congress to make sure that those rules are followed when they write them.
To accept the idea that Section 403B applies in the way the government advocates here would be to accept the proposition of implied repeal of provisions of the 1984 Act. Nothing in the 2018 Congress suggested that Congress intended to limit the scope of considerations that the Sentencing Commission would authorize. I would accept, though, that under your hypothetical as you posed it, if the Sentencing Commission came and said it shall apply to pending cases, contrary to what Congress said specifically in the 403 provision, that would be ultra vires and outside what the commission did. But I would urge you to look at the words in 994T, which give the Sentencing Commission very broad authority to come up with factors, a list of criteria, and to explain the circumstances in which extraordinary compelling would apply. Justice Gorsuch, to your questions, I would suggest that the standard for dealing with an implied repeal are very strict. And so to accept the government's notion here, you would have to accept the idea that words that had nothing to do with compassionate release nonetheless were intended to impose limits, and that judges would be authorized to create limits. And yet that goes against a number of this court's canons. One is the idea we don't have an implied repeal unless there's a strict standard that is met. We don't ask for judge-made rules that interfere with congressional statutes that give broad authority. And the third is the idea that we would accept the principle that a statute that speaks directly to a question is somehow going to be negated in some fashion sub silentio by a later enactment. I would urge you also to consider that sentencing length is always part of these compassionate release motions. That doesn't mean that it is an automatic application of the revocation of the stacking that occurred in the 2018 Act. It could very well be that a judge says you're automatically would have gotten 18 years lower, but because of your prison conduct or because of other factors, I deem your reduction only to be 5 years. This court doesn't need to decide what the extraordinary and compelling circumstances are. It should be for district courts to decide that. All we're asking you to do is to say that judges are not authorized to preclude the consideration of factors that district courts can take into account. This is not a mechanical exercise. It looks at the individual circumstances of every inmate to determine whether, based on the totality of the circumstances, that inmate is entitled to a reduction. Thank you.
Thank you, counsel. The case is submitted.
All right. Ooh, it's so abrupt when it happens. Okay. That is the end for us. Okay. I want to talk there's a couple of things I want to discuss that came up today. So one of the things is somebody asked me to kind of run through the cases at the end. And the reason that I have a tendency to sort of touch on it but not go through it in too much detail is that I miss a lot of stuff while I'm listening. Good entry-level treatise on those canons. Reading law, the interpretation of legal texts. Oh, Scalia's book. Yeah, I may have oh no, I don't have a copy of that and I should get it. What I do have, well, and I'll show you because I'm about to talk about this in a second. Give me one moment. Is right here. This is my casebook on legislation and regulation, statutes and the creation of public policy, which is kind of about how to write laws. And so the thing is that we have a set of rules for how to write laws, and we have a set of rules for how to read laws, but they're kind of the same set of rules in a lot of ways, because we sort of presume that everybody, well, like I said, the people who actually get elected usually don't know these rules, but they hire people who do. So they make sure that when these laws get written, they get actually written, the text is actually written by somebody who knows what these rules are. And there's a lot of rules. Generally, the easy, like shorthand way of referring to them is the canons of construction, or the canons. Well, sometimes the canons means canons of construction. Sometimes it means canons of ethics. I don't know why. Lawyers love these words. But the canons of construction they're a bunch of rules on logic. They're logical rules, and they're so central to kind of how a sentence has to be written and how something would be read that they're kind of beyond reproach. So people have asked me before, like, well, it's not in the Constitution, it's not here, it's not there. How can they be relied on? And the reason they're relied on is that they are somewhat infallible. They are, some of them, like I said, are thousands of years old. Some of them go back to Roman or even Greek times. And they're things, and I'm not going to be able to think of one off the top of my head right now, and I've studied these all the time. I love them. I'm fascinated by them. I actually do know a bunch of them by heart, but of course when I'm trying to pull them out of my head, I can't think of one. But it's a lot of things about, it's very, very like 1 + 1 has to equal 2. And it's a lot of kind of language versions of that. And so if 1 + 1 has to equal 2, well, when I'm writing a law, I make sure that part 1 and part 1 equal part 2. And when I'm reading the law, I know that 1 and 1 have to equal 2, because they are just implications. They're just logical. The only way to think these three things through logically. So that's all called the canons of construction, whatever. Congress, legislature, people who get elected, they come in and they make decisions. And so, we talked about, there's this question about when someone gets a sentence, should they be allowed to have it changed? And one of you said, no, I don't think you should. And Congress got together and looked at a bunch of different stuff and balanced all of the pros and cons of letting people have their sentence changed. And a lot of them are things that we aren't going to think about readily. They're going to be things like, how much does it cost to keep an older person in jail, to pay for their medical care and everything? Is it cheaper once they've been in there for 30 years, once they're no longer a threat to anybody? They've definitely paid their debt. They're no longer a threat to anybody. There's really no reason to keep them in here anymore except sort of just because, and they're costing us a ton of money. Should we let them out and save the money? And that sounds very heartless, but that's going to be one of the things that they think about. And they're going to think about all these different things, all the pros and cons. That, at the same time, if you build in something that says, a 50-year sentence is never going to be a 50-year sentence, then why does somebody care if it goes from 30 to 50 years? So that's the counterpoint to that. And Congress all gets together and they think about these points and counterpoints and they balance them and they decide what they're going to make the law in the end that balances all of these things. We let those decisions, the balancing decisions, those are called policy decisions, get made by elected people, people that we chose, human beings chose to send to Congress and balance our interests and make sure that what I think, somebody's sitting there going, hey, wait a minute, I think this. And so those are the people who make those decisions. Judges don't make those decisions. Judges are not supposed to make those decisions. Every once in a while, Congress will write in, we also want you to consider the policy. But generally, judges aren't supposed to make those decisions. What they're supposed to do is sit down, look at the law Congress wrote after balancing all those factors, and say, well, in this situation here, the guy who's sitting in front of me with this set of facts, with what happened here, I'm not sure that what Congress wrote applies exactly, like precisely. So how do we figure this guy's circumstances out with the law that we have? Because it's a little bit different. And so the court sits there and they have these set of rules that they go through, these canons of construction to interpret the law that Congress wrote. But one of the base ideas is that we assume that Congress knew what they were doing when they wrote this law, because if not, then you go down a whole side rabbit hole of, and it's good to at least have some place to start. And so what we start with is what the words actually say. We assume that the words are intentional. I want to say always, but nothing's ever always. It's the law. But that is the theory, okay? And so that is also why we don't, in a lot of cases, federally in particular, we don't often elect judges, is because when a judge sits down and looks at this situation and this law, we don't want them to think about, we want them to just apply the law to this situation and use those rules we told them to use and figure it out. We don't want them to think, is this going to make people mad? Because I think people are going to like it better if I go this way. We don't want them thinking about that. So we don't have them get elected. We have them get appointed and all of that stuff. So they're set in there by people who get elected. So there's obviously some politics that go into it. But that's the reason that judges are on the bench for life. So we don't ever want somebody being able to come in there and say, if you don't decide the way I like, I'm taking you off the bench. Now, some states do it differently. Some states do have judges get elected. I don't particularly like that idea. I think somebody in the government should not be thinking about what people want, but should just be reading. But I'm also a very stubborn legal geek. And I really love all of this interpretation stuff, and I like the idea that you can kind of stick to it. So, whatever. Okay, but there were a couple of questions that were asked that I wasn't able to get to, and a lot of them related to interpretation and to policy versus interpretation, which is a huge thing that I think is fascinating and interesting. And also, someone asked why we don't elect judges, or why judges aren't elected, and that's the reason, is that they're doing a different job, and that job is not supposed to be influenced by the popularity of the decision. Deciding whether or not to allow people's sentences to be changed, that's a policy decision. There are good and bad outcomes. Somebody's got to balance those good and bad outcomes. And that person, the person who balances those, we do want that person to be accountable for their decision. That's a politician. That's what they do. So that's how all that works. The other thing was, I realized at some point that once I said that, yes, I would give you guys a rundown on everything, I kind of stopped paying as much attention to you and started taking notes. And then at some point I was like, you know what? I'm going to stop doing this because I really should be talking to you guys while I'm live, and I'm not going to get the best stuff out of this anyway. Very many are clearly partisan, elected or not. Absolutely. And it's funny. I try very hard to, I don't always do it, of course. You know, sometimes the brain just says whatever the next word is, but I try to separate the words political and partisan. Political, technically, in my context of the word, means elected. Partisan means making decisions based on your party. And you're absolutely right, because they get chosen by elected people, and then they get confirmed by elected people. So of course they're going to be partisan. But we do find over time that usually when a judge comes in, especially to the Supreme Court, they're usually very partisan. And over like a year or two, they tend to even out a little bit because they start to realize how much flexibility they really have. And the fact that they're kind of untouchable, and they start to kind of push the boundaries a little bit. And I want to say, no matter what judge you're talking about, they're almost always a disappointment in some case to somebody who put them up there and was very excited about them. Because at some point they realize, oh, I can get away with this. I can really follow what I think here, and there's really nothing anybody can do about it. And so they tend to do it. So that's why you'll see things like Gorsuch sometimes is going to give you opinions that are going to blow your mind. Barrett is definitely making some shifts. It's why I'm very excited. Somebody just sent me her book off of my wish list. So thank you very much, whoever that was. It'll be here in a day or so. And I realized I really want to see what's going on in her head, because she was a law professor, and she was, right at the beginning, she was definitely coming in hot with the partisan stuff, but she is really starting to carve out her own space. And it occurred to me the other day, and I hope this is safe to say, but that particularly for a lawyer, I want to say a lawyer who's a woman, but kind of a woman in any field, It can be hard to push forward in a lot of fields with kind of a complete lack of concern for how your opinions are going to be read. I think you're generally held to a different standard somewhat, and you really do have to push a little harder. And it's almost like the Supreme Court is like the one place you can get in there. And oh, it was you, Drunken Mist? Thank you. Where you can, she can come in. She's probably spent a lot of time qualifying some of her thoughts to make sure that she was able to move forward, and is finally realizing she doesn't have to anymore. I don't know. That might be totally off base, but it did occur to me the other day that there's not a lot of places where there's total freedom. Okay, there was that. So a quick rundown of, we had these three cases. These were all about sentencing guidelines and the shifts in sentencing guidelines. And the kind of cool thing here, I think kind of interesting, is that this law, let me see, make sure I use the right phrases. Compassionate release statute was written in 1984. But around the same time, there also was a change, and probably the same law, there was a change in the how they set up the sentencing guidelines as well. Oh, that's right. They wiped out, okay, hold on. So what actually happened is that they wiped out, make sure I don't get this backwards, parole. Federal parole used to be, you were in there for 15 years of your sentence, and if we feel like it, we can cut the last 10 years off and let you leave, but still be kind of under our eyes. Keep a view on you, and keep a look at, make sure you keep your nose clean, or else you go back into jail. And they wiped out parole, except in certain situations. Sorry about that. YouTube just moved to the next thing. Except in certain situations. And those situations were two situations. It was the compassionate release. There's probably a few others, but the ones that I know about were these compassionate release statute. The two ways you could be let out early instead of parole were you're over 70 years old, you've been in jail for 30 years, and a third thing that I can't remember right now. And in that case, they'll let you out. And like I said, that's usually about not wanting to pay their medical bills anymore. It's less about anything else, but it's always discretionary. The judge would have to decide it. And then the other was this compassionate release under the extraordinary and compelling reasons. There's some sort of extraordinary and compelling reason that this person should be let out early. This always had to be brought by the prison, the Bureau of Prisons. They had to be the ones that brought it to the judge and said, hey, we want to get rid of this guy. He's costing us a ton of money or whatever. And then but then the other thing that was going on is the Sentencing Commission would set these mandatory minimums. They're not called mandatory minimums, Brian. Stop saying that phrase. We keep using it, but it's not correct. It was sentencing recommendations. But the sentencing recommendations were binding, so they were mandatory minimums. So even though we had this rule that you could release people early, since the sentencing recommendations were binding, you couldn't release them early because it would have conflicted with their binding sentencing recommendations. It said 30 years, you can't let them out early because the sentencing recommendation can't be adjusted. Well, in 2005, this case Booker came along and said, the sentencing recommendations are no longer binding, now they're just a recommendation. So that opens up this ability, even though the parole system was closed, it kind of opened up the chance for a few more people to be not paroled, but paroled. You're not supposed to call it parole, but it's basically parole. But it still wasn't used a lot because it always had to be brought by the prison system. So it had to be somebody they really wanted to get rid of. And then in 2018, is when the Congress went through and rewrote everything. It's the First Step Act. They rewrite everything. And this rewrite includes a change that, that says that it's no longer only the Bureau of Prisons that can bring this. People can bring it themselves under certain circumstances. It has to, basically, if the Bureau of Prisons doesn't bring it for you after a certain period of time, you can bring it yourself. And so that brought a ton more of these cases into the court. A ton more people came in and said, I am 80 years old. I've been in this jail for 35 years. Can you please let me out? I can barely walk. And the court started letting a lot of these people out, and it turned out, but still not a huge change until 2020. Because in 2020, we had COVID, and all of a sudden, there was going to be a really big problem if all of these 70 and 80-year-olds had to be kept in, separate places so they didn't get infected. It was going to be a nightmare. And so having them all be able to come to the court themselves and manage their own thing and get themselves was probably saved a lot of trouble, but it sped up the use of this. And all of a sudden, these extraordinary and compelling reasons start getting used a ton. Even though it's a 40-year-old law, nobody's really figured out what compelling and extraordinary meant yet, because nobody had used the law that much. And that's why we're just now getting to it. That's why we're just now figuring out what this means, because all that Congress said was any, a compelling and extraordinary reason. And then they let the courts figure out what that meant. So that's what we were talking about today in both of these cases, is whether something was extraordinary and compelling. And the first one, the big thing was that, this guy had been given a really long prison sentence while his co-defendants were given short ones, because all of his co-defendants took deals and gave evidence against him. And the judge said, and the guy kept saying, the reason he didn't take a deal is because he said, I'm innocent, I'm being framed by these other guys. But didn't matter. He lost. And the judge came around later, like 10 years, 12 years later, and said, it was the same judge, which I didn't realize till this. And he said, I remember that. It didn't feel right. Something's wrong. And so between the fact that I don't trust the other, those other people who gave, your co-defendants, I just found out that they all got like tiny little sentences while you got this 40-year sentence or whatever. It was, by the way, it was gross. I'm not telling you what happened in the crime because it's gross. But so it's not, these are not lovely characters, but that's not really the point. And also the third thing was, and you're probably innocent. So based on those three things, I'm going to let you go. I think those are extraordinary and compelling reasons to let you go. So he did. And the Third Circuit, I think, or Second Circuit, whoever it was, Second Circuit, said somebody not taking a deal and getting a higher sentence is not extraordinary. It's ordinary. It's what happens every time that happens. So that's not extraordinary or compelling. So neither of those two reasons really work. Those are just normal. That's just kind of what happens in our system. And so it was just down to that third thing, the fact that he was likely not guilty. And so the big argument now was whether likely not guilty kind of on its own could be extraordinary and compelling. And the government said it can't be, because that particular argument goes into another statute. It's not part of the extraordinary and compelling argument. It's part of a habeas corpus argument. You can only bring it under that. And the discussion became, kind of in all of these cases, whether the court's allowed to, even if these two maybe not, but then that one maybe, but when you push them all together, it's enough to be extraordinary and compelling. Is the court allowed to push them all together even when individual ones are supposed to be parts of other discussions? And that's really what we ended up discussing kind of in both of these cases. And I would sort of be surprised. Usually when they bring two cases like this, if they've kind of already decided what they want to do, it's because they want to make a line between them. I'm not totally sure, because I thought it was going to go one way and it kind of went the opposite of what I was expecting. I feel like they were way more receptive to the first argument than they were to the second one. And I actually thought it might be the other way around. But because the second one was about whether or not, in the second case, the sentencing guys, the guys who write those second sentencing recommendations, said, hey, if Congress says what a sentence is supposed to be, and then they change it, even if they don't say in the law that we're applying it, we're going to apply that change retroactively. In some circumstances, when it's really extreme, we're going to let the judge. We recommend that the judge go ahead and let the person out early. And it's if the person has been in for at least 10 years, if it's an extremely long sentence, which one of these was 70 years, and if it's if there would be a big difference, a gross difference between what they would have gotten and what they did get. And the question was whether the Sentencing Commission is allowed to do that or not. And I thought they were going to side with the Sentencing Commission because the Sentencing Commission is supposed to be given a lot of deference. I don't think that's not what I heard. I didn't hear them really on that side. I kind of felt like, no, this is the problem, is what I'm going to do with the rest of my day. I'll probably listen to this again a little later, and then I'll sit and think about this for the next 2 days, and I may very much change my mind. That often happens. But there's little bits and pieces of it that are stuck in my head. But that was kind of what got in there for now. So anyway, and then the other thing that was kind of interesting is that the guy brought up Loper Bright, which is about whether or not people like the sentencing guideline people who write regulations, whether their decisions can overrule well, it's supposed to be whether they can overrule the court, not overrule Congress, but they said it as if it was overruling Congress. I don't know. Loper Bright is the thing that knocked the Exxon case out. Anyway, all right. So that is where I am right now. I hope that wasn't too much rambling all in a row. Do you guys have any questions right now? I'll see if I can... like I said, usually by the end of this, there are so many little tiny pieces of data just crammed in my head that I'm trying to sort through that it's... they're all just kind of... There's like little Post-it notes all over the wall. It's a mess in there, so I have to go through and kind of reorganize them a little. But let's see if you got... Let's see, what did I miss anything here? Justice Jackson brought in her experience. Yeah, and there was something else really... Oh, and the whole thing about... I thought, was it Jackson or Kagan? It must have been Jackson. I thought it was Kagan who said... that was discussing... One of the big things here is that the judge in the first case said... he had and this is a quote, a certain disquiet, which is a very judgy word to use, about the, speaking of judgy words, the veracity of the co-defendants who had given evidence, about whether or not they were telling the truth. And of course, he had already listened to that 10 years ago. So why the sudden change? And the reason for the sudden change is, well, he didn't realize that they were all given these tiny little sentences in exchange for their testimony. And once he realized that, he was like, something doesn't smell right here. And particularly the fact that the defendant keeps saying, this, I didn't do, keeps swearing, I had nothing to do with this. But the justice said, I've been a district court judge, and that sense of disquiet is just something you have. That's just something that happened. You have put someone in jail for the rest of their life. You're going to feel weird about that. That may not be enough, or is not enough on its own, or may need something more, or something. But that's just kind of a feeling you get when you're a judge, is, did I do the right thing? And that's just something you're going to have to deal with it. So books I would recommend to start collecting. Well, first of all, learn how to IRAC. I have a video on it. It's somewhere in my my Civics 101 playlist, probably near the beginning. Learning how to IRAC is super, super important. It'll change the way you think about stuff, but it'll change the way you watch and learn. IRAC is the name. It's Issue, Rule, Application, Conclusion. It's how lawyers read, write, think. And it's why you see down at the bottom here that I named these things the rule and the issue, is because everything is it's an issue, then it's a rule, then you apply it, and then you conclude. I have a lot of case books, but they're a little bit hard to. I got to say that, yeah, the John Grisham books when I was a kid definitely got me in here. I think a lot of this has to do with what draws you to the law. A lot of my favorite books that I think of in the law are a little more philosophical or historical in nature, because that's the part that I love, but it's not necessarily the part, it's definitely not the part that everybody loves. So that's a different thing. One of my favorite books that I keep coming back to is America's Constitution by Akil Reed-Amar. Just such a great book. But yeah, it's just hard to say. I'm just looking back here at things. So I'm sitting here like, well, obviously Aristotle's Politics, but not moron. What idiot other than me reads, gets that into their head when it comes to law books? So I don't know. It's hard to say. This is a good one. That book I just reading something called the Great Descent, I think is the name of it, which was pretty interesting. But it's more of like a narrative. 1776 by David McAuliffe, just to understand kind of what you're dealing with when you go in there. All of this stuff I think is important, but it's hard to say. I'm not giving you guys a good answer. Wants to be a corporate lawyer, yeah. And that's the thing, is that we're probably looking at different things, and so I feel like my answers aren't going to be great. But learning to IRAC is always going to be important. That is like number one, and practicing it. Practice IRACing. Get some as short as you can cases. I will say this over, you guys have heard me say this before. Justice Thomas is the easiest to IRAC. Try to find some short Thomas decisions and IRAC them. Locate the issue, locate the rule, locate the application, locate the conclusion, and see how they're laid out. And then I usually, what you do at the beginning is you rewrite them. You write what's called a brief, which is a short version where you just write, the issue is this, the rule is this, the application, the conclusion. And there's usually like several. Aren't they all? If you could find that further, sorry. I'm a little pooped. It's been almost 3.5 hours. I had one other thing I was just about to say about that, and now I can't remember what the heck it was. Oh well. But yeah, Thomas cases are usually very clear. Did Fernandez, if you guys want to come back, the YT, I think it takes a little while to process, but once I close this, it takes like a couple hours, I think, for them to process it. YT will put this whole thing up over there, and you'll be able to watch the whole thing there if you want to. I did realize that when I was on YT, I accidentally left the scroll at the bottom set to the wrong case for like the first hour, maybe even longer. And so I changed it like the last minute, but it's going to be a little bit Sorry about that. You can, if you want to get a rundown of what these cases were, the morning decision this morning, well, yes, Thomas's decisions. The morning report this morning will run you through these cases real fast. But of course, when I do the morning report, I'm guessing what they're going to talk about and trying to define all that stuff. It's not always what they actually talked about. But I'm usually trying to give you guys like as many keywords and phrases to listen for so that you'll be able to keep up as much as possible. And somebody said this earlier, I can't remember, but sometimes I can't keep up. So don't feel, somebody said that, it's so hard to keep up. Yeah, I know. It's hard for me to keep up. But any ruling, when the rulings will be released, usually June. These usually come out in June. So these take a little while. So this is the last case for November. The next case will be December 1st, which doesn't mean I'll be gone. I'll still be doing morning reports and stuff like that, but I won't be doing SCOTUS live. I'll be responding to whatever they put out, but not doing their live things unless they surprise us. But I think December, let's see here. December 1st, we have a Bondi case, so that might be interesting. I mean, sure, that'll be interesting, but so that's not, a couple more weeks, which gives me some time to play with this computer setup and get it actually working really well. Desiree, both of these cases today were about compassionate release. This was all compassionate release. And that's the short answer. They were actually both. It was all three. There were three cases about compassionate release. The second two were almost the same case. It was kind of interesting that the two lawyers had different approaches that kind of contradicted each other. I would like to know, in general, particularly from the TikTok folks, whether this scroll, I got rid of the third scroll after what people said last night, but was this useful? I was trying to cut down on, having to keep explaining over and over again what we were watching, what the general questions were, try to keep like a general thing going on. But I also know that having something moving the whole time is a little bit annoying. So, okay, all right. I have a schedule for when I go live. I go live for all of the Supreme Court things. I do not have a schedule for when I go live in general yet, because I'm going to actually uninstall this whole system and reinstall it and start from scratch, because I think I've made some mistakes that I need to start over with, so it's going to take me a little while. But once I get it working, I hope to have a good, solid, regular thing. But I do go live whenever I can in the meantime, so I'll just be sort of popping in and out. And then every morning, or most mornings, I probably won't have one tomorrow morning because I'm going to be exhausted, but I put out the morning report, which is just a quick rundown of federal court law from the past 24 to 48 hours, and just kind of what a few of the biggest recent opinions were, and updates on federal case law. They're usually about 10 minutes. They go on both TT and YT, and also on Substack. I gotta watch it. When you say those words, you get in trouble with one of these places. Anyway, all right, guys. I'm glad to hear the scroll worked. I was really excited about it once I got it going, so I'm happy to hear that it worked. It was a wrestling match, but I'm glad it worked. And thank you all very much. If anybody hasn't subscribed and would consider subscribing, I would appreciate it. Or I've got in my bio on my profile, there's a link, which is a tree, which will give you links to other things, other ways. There's a wish list. There's some other stuff. Particularly, there are some wires on there that I could really use. Because I'm trying to get all of these things wired together, and a hub, which are annoyingly, hubs used to be like $8. I'm very annoyed at how much more expensive the hubs have to be, but it is what it is. And there's a couple some food, because that's what I'm doing. All right, thank you everybody. I very much appreciate it. Have a wonderful afternoon, and I'll post anything that comes up, and I will talk to you all soon. This will all be again on the YT later. All right, have a great day, everybody.